File your reply.
We have filed. Check.
Reply is not here.
My lord.
It doesn't seem to be here.
Just filed yesterday, my lord, with a copy to my learned friends. I can just hand over a copy, and in the meantime, if I set my export. So what I have done is, my lord, I have prepared a written argument dealing with the submissions which were made earlier by both the parties, and also the issue of ITC in just one paragraph in the written argument. My lord, before you lordship put the affidavit, may I just point out in the written argument, my lord, the last paragraph. In one paragraph, I have summed up the entire thing. So may kindly see the last page, my lord. The last page. As regards the argument made on behalf of the railways, that since the petitioner is getting input tax credit, that is ITC, it is not entitled to reimbursement of tax component as per PVC clause as claimed in this petition. It is submitted that even if the ITC is available to the petitioner under section 17.5 of the CGST Act 2017, the same is passed on to the railways in terms of section 171(1) and clause 3.7 of the letter dated of the Government of India Ministry of Railways, Annexure 1, page 5 of the affidavit filed by the respondent of 4 on 27/5/2022, which will be evident from the CC bill of the petitioner at page 268 of the affidavit filed by the respondent of 4 on wherein an amount of rupees 31 crore 26 lakh 3,000 was reduced from the bill of the petitioner, being the refund of ITC post GST. It is thus evident that it is relatable to the CC bill of the petitioner, and it has nothing to do with the PVC claim relating to tax component. This is the position. Lordship will permit me to point out the section 17.5, although initially possibly I possibly stand correct. I am not very expert on this etc. But so far as 17.5 is concerned, now my instruction is that yes, it may be available to us. I do not know how, but then now Lordship kindly see section 171 of the CE. Even if I get it, it has to be passed on to the railway.
It's the
For the time being, I am handing over extra copy of the book.
got it.
Yes, section 170.
One
171.
Okay. Yes.
Anti-profiteering measure. Any reduction in rate of tax on any supply of goods or services, or the benefit of input tax credit shall be passed on to the recipient by the way of commensurate reduction in prices. So even if I get it, I have to pass on to the railway. I cannot evade it under section 1. Not only that, my lord, even the railways have confirmed this, my lord, that your lordship will find from page 5, annexure 1 of the affidavit filed by the railways on 27/5/2020.
27/5/2022.
My lord.
22.
20.
Yeah.
Lordship will kindly turn to page 5 of this affidavit, my lord, filed by them.
Yes.
This is a letter by the Government of India, Ministry of Railways, number so dated 27th of October 2017. Subject is impact of GST on existing works contract. Now, let me kindly turn to the next page, page 6. Next page.
Yeah.
Paragraph 3.7. Recovery, if any, which is required to be done from the contractor, may be regulated as per section 171(1) of the CGST Act 2007. Not only that, my lord, there is another material, that is, my lord, the affidavit filed by respondent number 4 on 1st of March 2023.
Yes.
The last page of this document, my lord, there last time my learned friend pointed out that it is there, but then what is the true interpretation? This is a CC bill of the petitioner. From there, lot will find that from the bottom, my lord, they have numbered as A, B, the first column A, B, C. Lot will find against serial number 4. Just below serial number 4, there is a word less. Then right hand side, input tax credit for refund post GST. This 31 crore 26 lakhs and 3,164 was deducted from my bill, which I got, and from it was the final bill was C, difference payable B minus A, 62 crore 70 lakhs. So this 31 crore that the GST input tax credit that was made available to me, I have returned to them by way of deducting it from my entitlement in the system. And secondly, my lord, as I have mentioned in my written argument,
So you are saying that you are not entitled to this 31 crore.
here, initially, although it is made available to me, but by way of section, because of section 171 and their letter itself and this bill, it will be clear that we have to pass on to the railways, and we have passed. So the argument that you are getting input tax credit at the same time you are claiming reimbursement of tax component to the PVC bill, this argument will not hold water. This is the reply. Their argument was that on the one hand you are getting the benefit of ITC, why should you also get the benefit of the tax component? Price variation they have given to me. Tax component in the under the PVC clause, I am not entitled because I have got ITC benefit. This is the position of the item.
No, if I remember or recollect in respect to the instant matter,
Madam.
the original price of steel at that point of time was a particular amount.
Right.
The price of steel have increased.
Right.
And because of that, there is this PVC.
Right.
Now, with the increase which has happened,
Right.
there's obviously an increase in the GST.
Right.
Tax component, there will be an increase.
Right.
Now, in that increase which has happened because of that,
Right.
originally, if it is 100, now if it has become 200, you are claiming the GST on the increase by 100.
Right. This is one. Your lordship will recall. Your lordship also say that either increase or decrease, it doesn't matter. What matters is, supposing today this price of steel is this much, it may have reduced also after GST. But the fact that I have to purchase post GST and I have to purchase more, so there will be a expenditure on tax through that is GST now. Now, even if it is less, I have to pay tax, but I am purchasing. The price may have come down, but in quantity I have to purchase more after the CGST has come into force. So your lordship will recall, your lordship will say that either the price increases or price decreases, doesn't matter. What matters is that after the CGST introduction, since I have to purchase under the PVC,
No, isn't it the section 171 is on the basis that if on account of the GST, the price decreases,
yes,
then you have to give the benefit out there.
yes,
To the,
yes.
I don't think section 171 is in relation to price increasing.
171 is actually benefit of input tax credit by whatever way.
No. You see, like why it start any reduction in the tax of rate of tax.
Actually, a lot with that. The very caption says anti-profiteering measure. I should not be able to make any profit
on the basis.
Right.
And as such, you would not be entitled to that tax on the basis of which there would have been a profit.
Hello, Your Lordship. Just permit me, I'm sorry to interrupt you. Although it says anti-profiteering measure, there are two things. Any reduction in rate of tax on any supply of goods or services, or the benefit of input tax credit, or in respect of both, even if it is the input tax credit which doesn't really is a profiteering measure, even then, since it's a benefit I'm deriving, I have to pass it on to the rate, and I'm passing on. So that way, also, it has got no relation with the calculation of PVC. So for a tax component, is concerned. Very clear.
Because there are two aspects.
My lord.
Any reduction in the rate of tax on any supply of goods
Or
or services.
Or
That is
the
one.
benefit. So both.
So
Your
that is
Lordship
one,
right.
if there is a reduction.
Yes.
Or if you get a benefit, earlier the benefit was not there.
under the GST,
Now you are
available.
getting a benefit because of this input tax credit.
Yes. And under
Then
the
you
GST,
have to pass on that benefit
Yes.
to the recipient.
either way.
Either.
Yes. Then. So that being the position, my lord, the argument that was made subsequently at the late stage, that since you are getting ITC benefit, you are not again entitled to the benefit of PVC so far as tax component is concerned. So far as price component is concerned, that they have
No. Here there is no quarrel with the proposition
Right.
that you are entitled to the PVC.
Right.
For that, they have already paid you the PVC.
Yes.
We are only concerned as to whether they are liable to pay the tax or not,
Yes. That is also
which
part of
should
the PVC.
increase with the increase in the price.
Yes. And here possibly I'm just indicating, and earlier your lordship also said that there may not be increase in the price, but what the PVC clause say that when I make purchase subsequently, I'm sorry, no, increase in price is there. Your lordship is absolutely correct. Increase in the tax, I'm saying tax may increase. May
Because
not,
without the increase, there is no PVC.
absolute. Yeah, I'm sorry. Absolute. Price must increase in order to enable me to invoke the PVC clause. Price increases, tax may get reduced. That doesn't matter. Since the price increases, I am entitled to price difference, and along with
No.
there will be tax component also.
No, the reason why it is so,
Right.
because if the price increases,
Right.
the tax also increases proportionately, taking
Exactly,
it on ad valorem.
Absolutely. That is
So therefore, there is an increase in the price.
yes.
Now, whether you get if you have availed the input tax credit on that,
Yes.
then would you be entitled to? I don't think you would be entitled to then.
No, the ITC is completed, is not relatable to PVC clause matter, as I explained. ITC, even if I get any benefit, I have to just pass on to the railway. So there, neither I am getting any benefit from the ITC, nor it has gotten relation with the
That is what the GST said.
minor.
In this thing, in view of 17.5, you are not entitled to the GST.
That's what I said. If I go to the bill and my instruction says, even if it is available, it has to be passed on to the railway, and we have passed on. We have reduced from our bill that 31. So that being the position, it has got no relation with the PVC clause, and my entitlement remains. And other things which they argued, my lord, I have replied with this written argument. One thing which was possibly coming up, that the word GST is not there. It was not there in the initial agreement, which your lordship was indicating that do I have to take recourse to the sale of goods act at particular. And here I've developed one argument subject to lordship. A similar issue arose in case of PVC clause only. There, my lord, there was the agreement between the parties that in terms of PVC, I am entitled to any increase in the price. The price of the goods as such there was no increase in the price of goods as such. But then wages of laborer was increased. Now the question came, can we read into that PVC clause the increase in the price because of increase in the wages of the labor? In that connection, there is a High Court judgment of Bombay High Court, I just give a copy, which says that we have to take Moore-Coke test. We have to apply the business efficacy test, and we have to read it into. We have to accept that it is implied in it, and relying on the judgment of Supreme Court, my lord, in the Nava Power Limited.
Which paragraph you are reading?
My lord, I'm just. My lord, there are quite a few paragraphs. Paragraph 1, possibly, may I just read of this 2018 SEC Online Bombay 104. I found it quite interesting subject to consideration. Paragraph 1, I am reading. The petitioner, a company registered under the Companies Act and engaged in the business of providing facility of management services, including the mechanized housekeeping and technical services, has invoked the writ jurisdiction of this court being aggrieved by the inaction on the part of the respondent authority to revise the reimbursement to the petitioner in the light of the increase in the rates of minimum wages and to neutralize the petitioner for the increase in cost of labor in terms of the agreement executed between the petitioner and the respondent railway. The grievance of the petitioner revolves around the nature of his contract, which is labor intensive, and cause of action of the petitioner is the refusal to neutralize the petitioner for the significant increase in the minimum wages by respondent number 3, Ministry of Labor and Employment, Government of India, by issuing a notification under the Minimum Wages Act. It is a specific case of the petitioner that in the absence of such an action on the part of the respondent, the petitioner is required to make payment of increased wages, which incurs him a huge financial liability, almost causing closure of his business, and he fears a worse situation where the trade union would refuse to continue with the work, thereby affecting the work of the petitioner. There are 3 months. The petitioner is a private limited company and is engaged in the business of providing cleaning and housekeeping services. In the past, the petitioner has been providing different services to the railways, including mechanized cleaning of this. We can skip, my lord. Just the next sentence. The respondent number 1 floated a tender for the work of mechanized cleaning of coaches, watering of rakes, including cleaning of depot premises and provision of on-board housekeeping services in the trains of so and so, the other terminus so and so. Now, Lord, may kindly turn to paragraph 4. I'll take a one to the relevant part. Paragraph 4, line about 5th from bottom in the middle line. As per the petitioner, Lord, as per the petitioner.
Yes.
As per the petitioner received consideration for increase in cost of services in terms of the price variation clause contained in the contract. The price variation clause, for short PVC, ensures that in the case of increase of consumer price index, the reimbursement of the payable to the petitioner is suitably increased so that the petitioner is not put under financial distress from the inflation, etc. If the CPI increases, the reimbursement due to the petitioner is accordingly reduced to ensure that the railways do not pay excess amount to the petitioner. The controversy involved with the present petition revolves around the PVC as contained in the agreement and as to the construction or interpretation of the said clause, and whether it would insulate the petitioner on account of increase in minimum wages, since minimum wages fixation orders are based on the very same CPI. It is the case of the petitioner that on so and so, the minimum wages applicable to the employees employed in the scheduled employment of sweeping and cleaning have been increased by 40%, and resultantly he is required to pay an amount of this so and so. Now, my lord, paragraph 5. As per the estimation of the petitioner, in view of the said increase, he is required to incur additional expenditure of rupees so and so for a period commencing from January 2017 till 2017 May. There are 7 minors. The petitioner company raised the grievance with the railways by making repeated representations, and respondent number 2 railway constituted a 4-member committee to recommend a suitable alternative for compensating increase in the minimum wages, with the realization that the mechanized cleaning contracts being labor intensive are essential one to maintain the train service. The committee constituting of the higher-ranking officers of the railways arrived at an option by which recommended that the labor component of existing price variation be frozen till so and so and be kept at a base price, and the subsequent increase to be adopted by using minimum wages paid on actual basis as per notification dated so and so. The grievance of the petitioner is that in spite of their recommendations made by the committee, the response number 4, that is the Chief Rolling Stock Engineer CST Mumbai, has indicated to the petitioner that the proposal was rejected, meaning thereby that the petitioner will have to perform the contract as per the existing PVC and continue to bear 40% hike in the minimum wage in terms of the notification dated so and so. The petitioner has therefore invoked the writ petition of the court on the ground that it is only efficacious remedy available to him, and he has sought to direct the direction to the respondent to implement recommendations of the committee and to revise the petitioner's reimbursement under the contract to compensate him for the increase in the cost of labor. Then, my lord, possibly we can skip this paragraph subsequently. Paragraph 11, Lord Mechanics. The learned senior counsel, Mr. Swenso, would take us through the relevant clauses of the contract and would submit that the contract contained the PVC which permitted the amount payable on account of the price variation to be settled every quarter by a prescribed formula. Rest I am skipping that. Then, my lord, paragraph 12, where this Moore case has been brought in. Paragraph 12, my lord, from the bottom, maybe around 8-9 lines, my lord. Learned counsel would submit. Paragraph 12, my lord, from the bottom.
Yeah.
Learned counsel would submit that what is to be looked into is the decision-making process adopted by the respondents in declining the claim of the petitioner, which, according to him, smacks of arbitrariness. He would place reliance on the judgment of the Honorable Apex Court in the case of Nava Power Limited versus Punjab State Power Corporation Limited to advance his submission that while construing the terms of commercial contract, the principles of business
Let's come to paragraph 49.
My lord?
Paragraph 49.
My lord, yes, I would have read from the paragraph 49. You can take the direction. Yes. The Honorable Apex Court in the case of Nava Power had an opportunity to deal with the principle of business efficacy and applied the state principle to the tax in hand. The Punjab State Electricity Board had selected a developer through the tariff-based bidding process for procurement of power on long-term basis from a power station to be set up at a village in Swansea, Punjab. The said project was based on Part 7 of the Electricity Act 2003, which contained provisions for tariff. In order to facilitate the implementation of the project, TSEB incorporated the affiliate Nava Power Limited as a special purpose vehicle SPV for the implementation of the project, and the successful bidder was to acquire 100% share holding of NPL and to enter into a 25-year power purchase agreement with PL. On the bidding process being completed, LNT was declared as a successful bidder and the share purchase agreement was executed between Spencer, transferring the 10% shares of Nava Power to LNT. Certain issues arose in the course of contractual obligation which cover an issue of component of the costs of purchasing of coal, comprising washing related costs, including washery charges and denial of road transportation costs at the plant and at the time end. Now, paragraph 49. I'm sorry, your lordship, in fact, 49 I was reading 47. 49. The Honorable Ethics Court, on consideration of the rival contentions, invoked and applied the principle of business efficacy of the transaction. It placed reliance on the judgment of the Court of Appeal move of where Cowen L.J. dealt with an implied warranty and observed thus. Cowen L.J. Now, an implied warranty, or as it is called a covenant in law, as distinguished from an express contract or an express warranty, really is in all cases founded on the presumed intention of the parties and upon reason. The implication which the law draws from that must obviously have been the intention of the parties. The law draws with the object of giving efficacy to the transaction and preventing such a failure of consideration as cannot have been within the contemplation of either side. And I believe that if one were to take all the cases, and there are many, of implied warranties or covenants in law, it will be found that in all of them, the law is raising an implication from the presumed intention of the parties with the object of giving to the transaction such efficacy as both parties must have intended that at all events it should have. In business transactions such as this, what the law desires to effect by the implication is to give such business efficacy to the transaction as must have been intended at all events by both parties who are businessmen, not impose on one side all the perils of the transaction, or to emancipate one side from all chances of failure, but to make each party promise in law as much at all events as it must have been in the contemplation of both parties that he should be responsible for in respect of those perils or chances. The significant issue was the principle of business efficacy transactions which are intended at all events by parties who are business. Then para 53 probably, and that was just 4 lines from the bottom. Thus, normally a contract should be read as it reads, as per the express terms. The implied term is a concept which is necessitated only when the penta test as set out in BP refinery, and there has to be a strict necessity for it. The paragraph 54 minus is the concluding paragraph where everything has been summed up. Paragraph 54. We are conscious of the observations made by the Honorable Apex Court in para term that is sought to be read as implied is such which should have been clearly intended by the parties at the time of making of the agreement. However, it is not to be applied as a routine test to read something into contract on a disguise that the parties intended to be so. However, perusal of the contract agreement in the present case, it is amply clear that the railway itself intended to benefit the contractor by including the PVC with the above object to provide a buffer to deal with the hike in price variation in labor and material charges. The railway abided by this clause till so, and the contractor continued to receive the benefits of PVC in terms of the difference in the wages. However, the petitioner contractor felt the heat only when the minimum wages was escalated by 40%, and then the railway authorities concluded that the PVC clause related itself to CPI and would not cover the enhancement in the maximum wages. By applying the principle of business efficacy as laid down by the Honorable Apex Court, the irresistible conclusion that can be drawn is that the PVC cannot be restricted only to the formula prescribed in clause 12 of the agreement, but it also must cover within its ambit the escalated minimum rate of wages. Clause 14 of the agreement mandated the contractor to abide by the statutes like the Minimum Wages Act, Workmen Compensation Act, etc., which are instances of beneficial legislation in the larger interest of the labor class, and it is rather a bounden duty of the railway in ensuring that such statutory mandates are strictly adhered to in such circumstances. We are of the considered view that the respondent railways, though are at liberty to put an end to the existing contract with the petitioners.
So, on account of business efficacy reasons, the court brought in an implied warranty or implied term, which couldn't have been there at that point of time when the contract was.
Exactly. GST is something nobody known at that time. And I'll humbly submit, my lord, our case is better than this. We are not even trying to go to something which is not indicated. Here, tax component, excise duty, etc., VAT, etc., before GST, and the tax component as GST in the form of GST after 2007. So both are tax. Here, it was not even tax; it was CPI, Consumer Price Index. Subsequently, the Honorable Supreme Court says, no, even if there is an increase in the labor wages of the labor, that will also come within the purview of fees. So our case is, in my humble opinion, better.
No. Here, why should we go into all these things? Because the law, here, the thing has been made complicated. The different aspects of the matter, but otherwise, if we say,
absolutely,
price which was 100 has become 200.
Yes.
And now, because it has increased to 200, the as the tax is being calculated on FRM, there has to be an increase in the price.
And that difference we are creating in terms of the PVC, and they themselves by filing affidavit and otherwise also they state that unless there is a novation of contract, both the parties are bound by the initial agreement, and there is admittedly no novation of contract. That's my sir. Earlier arguments I am not repeating where I have mentioned in my written argument.
Anything?
Malab, from the day one, Malab, I am submitting Malab, that they are getting ITC. Malab, I can give the date Malab, when Malab, I have asked finally affidavit in opposition Malab. It is probably in 2021 Malab, where I have stated Malab, they are getting ITC. Malab. They are getting ITC. Malab. And Lordship is hearing this matter for a couple of days. Malab. I am Malab, every day Malab, I was submitting it for your Lordship. Malab. They are getting ITC, and their submission is that they are not getting ITC. Malab. Today, my lord, yesterday they have filed the affidavit reply, my lord, which I have sent to the authority, my lord. I have not received, my lord, any communication from them, my lord, regarding that, my lord. But, my lord, they have admitted the fact that they are getting the ITC, my lord. And, my lord, the ITC, my lord, they are showing, my lord, section 171, my lord. So, my lord, we have this APC itself says, my lord, it can be reimbursement or, my lord, it may be reimbursement, my lord, but if you have what the exact word, my lord. Yes. It may either reimbursement or recovery, my lord. If it may also be recovery, my lord, in some cases, my lord. So, my lord, as per 171, it may be some at some point of time, it may be recovery from them, my lord. And, my lord, they are getting the ITC, my lord. Now, my lord, they are arguing, my lord, there is some differences in calculation, my lord. My lord, their case is, my lord, that they were not getting the tax. Now they have admitted that the fact that they are getting the tax, my lord. Number one, my lord. They are getting the tax, my lord.
The number one is so overwhelmingly that you must have forgotten that. Number two.
No, my lord. My second point, my lord, I just forgot, my lord, what I wanted to submit, my lord.
Because all along you have been arguing only on the first point.
Yes, my
That is
lord.
where you
Second,
are
my lord.
forgetting the
Regarding,
second
my lord,
point.
regarding the other point, my lord, my lord, labor payment, my lord.
Huh?
Labor payment, my lord. My lord, service, regarding service, my lord, tax on service, my lord. My lord, my lord, what is their, my lord, prayer, my lord? What is their prayer? They are claiming, my lord,
No,
the
Mr.
tax
Goswami, kindly
on,
understand.
my lord, still.
No, Mr. Goswami,
Not
kindly
service,
understand
man.
what he is trying to say. But you see, even there is an exponentially higher labor element being brought in. Because if you see in paragraph number 11
My lord,
of the judgment which he is referred to,
my lord, I have
it was the specific submission of the respondent therein. Then look here, we have entered into an agreement. This is the amount on which we have agreed. We are not going to pay you more than that. But however, from the month of February 2017, in that case,
my lord.
in view of a circular being brought, there was an increase by 40% the labor wage.
My lord.
Then the Bombay High Court says that look here, there is always the concept of bringing an implied warranty to the contract or implied term can very well be brought in. If it was not within the contemplation of the parties at that point of time.
My lord.
And therefore, this 40%
My lord.
was being brought in.
My lord.
And further, the Bombay High Court also took into account that in the contract it was categorically mentioned that the parties will be bound by the Minimum Wages Act.
Yes, yes.
And as such, when there is an increase to the effect,
My lord.
because you see, these circulars are issued under Section 5 of the Minimum Wages Act.
Exactly.
If it is being issued or a notification is issued to the effect, they are bound to give that benefit of the 40% which is increased.
Well,
So it is in that perspective the senior counsel has mentioned.
my lord, my lord,
Therefore,
exactly, my
your
lord,
first
I-
argument remains
uh,
only
my lord,
that they have received the ITC and as such the question of getting
Well,
further
the
amount does
confusion
not.
created by the section 17(5)(b) or C, my lord. So, my lord, now that has been, my lord, to some extent, my lord, it has been clarified, my lord, that they are getting, my lord, and I was harping on that, my lord, they are in fact, my lord, they are entitled to the ITC, my lord. And my lord, if my lord lordship directs us to pay that amount also, my lord, it will, my lord, it will result in, my lord, double, my lord, payment of tax, my lord. They are claiming
Now
from the
tell me, you are saying that they are getting it. How are they getting it? No, you have explain it to me. Let me also be clear.
my lord.
You see, the circumstances, as I have mentioned in a very simple language, the price of steel was 100. The price of steel has gone to 200, for which you have given him the 100.
My lord.
There's no problem with that. You admit
Yes.
that yes, there is an increase of the price of steel. Now you are saying that while purchasing the 100, which he had to pay earlier a tax,
Huh.
the said tax was reimbursed by you
My lord.
earlier.
My lord.
But after GST,
My lord.
the price which has gone to 200 maybe,
My lord.
for which you have duly accepted, but in paying this 200, he must have paid 240 also.
My lord.
But this 40 rupees he is getting on the basis of input tax credit.
My lord. Exactly.
Where? How? Because you both of you will make your arguments.
My lord.
Then you will be putting me to the burden of thinking
Think.
that how. Because both of you have not explained to me how. You are saying that he is entitled to input rate. Section 17(5) categorically says that in the case of a works contract, the input tax credit is not given.
Huh.
But kindly explain how he is getting the input tax credit.
He's getting input tax.
You are saying
My lord. How
How?
he's getting
getting the input
credit, my
tax credit. Please explain that to me.
lord.
Then I
How-
will be clear. Then I can write the judgment in your favor. Rest I've all understood. His respect I have not.
my lord, regarding my lord, I am, my lord, submitting that regarding, my lord, inward supply, my lord. Regarding inward supply, in case of, my lord, works contract law, inward supply, my lord, he get the supply for construction of something, the steel. That inward supply, my lord, 17(5) is not part for that inward supply.
Meaning thereby,
Meaning thereby, my lord, when, my lord, he purchases this steel,
I gave you such a good example of 100, 200.
my lord,
You give me an example to the effect.
number one, my lord,
Yeah.
100, 200, there is a difference, my lord.
It will help
See,
also the
my
other people who are learning GST or tax,
My lord,
getting a knowledge of that. Now you are in live streaming. So the students can also learn how it is. Tell
my
me.
lord, I humbly submit, my lord.
Yes.
My lord, I am not in a position to, my lord, teach, my lord, to my colleagues, my lord, because I'm very much new, my lord. I have no hesitation to
Understood.
admit, my
But
lord.
if you
I
are
have no
saying,
hesitation to
no,
admit,
let
my
us assume you are saying that he gets input tax credit. How?
my lord, I'll try to explain. my lord.
Please.
Thing is this, my lord. When, my lord, there are two kind of bills. My lord, one is CC bill.
What?
CC bill.
CCB.
Cash credit bill. CC bills, my lord. Normal CC bill.
CCB.
CC
Oh.
bill. Normal CC bills. my lord.
CC bill will be current bill,
Yes, ma'am.
running bill.
Running bills. ma'am.
Oh.
That is different, madam. That is different. madam. The PVC bill is only for the amount, the increase amount. If the price of the steel was 100, he has purchased in 120. This PVC bill only for the 20 rupees, not 120 rupees. That is first one. So, my lord, the original price of 100, my lord, he cannot claim to PVC bill. So, the
No,
tax-
there's no quarrel.
But, my lord, the quarrel is, my lord, the lordship is asking me what will happen to the price paid for the tax paid for 100 rupees also. My lord, he cannot question or claim anything regarding that first amount of 100 rupees or tax paid in that 100 rupees in PVC bills.
Now let me put up it. Isn't it your contract that 100 rupees if he pays earlier, and along with that, if there is a tax,
My lord.
you are going to reimburse that?
Now, my lord, I will answer that. My lord. Lordship may kindly see this writ petition. My lord. Lordship has to go by this writ petition only. My lord. Writ petition, my lord. The original price, there is no dispute regarding payment of the original price plus tax. My lord. Here is only price variation from the price variation bill, and the price variation bill consists of only 20 rupees and tax paid on it at 20 rupees. My lord, the 100 rupees, what happened in the 100 rupees, my lord, I have never submitted on that, my lord. Neither, my lord, I have
You
made any-
first answer to me this way.
Right.
Isn't it the contract
My lord.
that if he purchases or uses the steel, and if he had purchased the steel at 100 rupees earlier, you are going to pay him, reimburse him this 100 rupees
Yes.
along with the tax?
Yes,
There's no quarrel with that.
my lord. Suppose, my lord, price
No,
has
no,
not
wait.
increased. Price has not increased. Suppose price has not increased.
No, forget about let us not go into the PVCL.
Oh, my lord.
The 100 rupees was the tax,
My lord.
was the price, and there was an increase. There is a tax element of 10 rupees.
My lord.
When he supplies, are you going to reimburse him 110 earlier?
My lord, here again, my lord, I'll show, my lord, the GST neutralization, my lord, in both, my lord,
Mr. Goswami, let us go to the GST later.
my lord,
Let
GST
let us go to the GST later. First and foremost, let us go and understand basic contract. Yeah, his contract was, isn't it the case that 100 rupees plus 10 rupees, 110 rupees, are you going to reimburse or not?
Yes, my lord.
Wait. Now, GST kicks in.
My lord, I'm saying yes. Though, my lord, I have not stated anything in this, my lord, in my reply, my lord. I have not stated anything regarding the original price.
No,
my lord.
no. I am
Just,
only
my lord.
asking you, isn't that the contract?
Yes, my lord.
That 100 rupees and 10 rupees.
My lord.
That is the 110.
Accept.
Now, how do you take care of?
That point. My lord,
No.
I'll show, my lord.
Let us not go into the PVC.
My lord.
How do you take care of? How do you pay after the GST has come in?
Exactly, my lord.
Yes.
Exactly. My lord, Lordship may kindly come to my second affidavit filed on 27th of May 2022, my lord.
Yes. What does it say?
My lord, it says, my lord, page 9, my lord, that is the internal page, my lord. Now, my lord,
Yes,
page
you
relation has been
have
said.
gone through the matter so many times.
No,
You
yes, my
just
lord.
tell me,
Yes, my lord.
how are you going to pay after GST
My lord,
without
after
forget
GST,
about
my lord,
PVC?
my lord, here is, my lord,
Are you going to
both
pay
the way-
110
my lord,
or 100?
no, my lord, there are two GST neutralization, my lord, here for original bill as well as, my lord, price variation bill. For price variation bill, my lord, it is given, my lord, the difference is, my lord, the VAT. The difference is VAT in PVC bill, and here, my lord, I'm reading from the, my lord, from this JPC, my lord, the tax liability of the contractor before implementation of GST is to be reckoned irrespective of whether the same was actually paid or not. The net effect of GST neutralization may involve either reimbursement to the contractor or recovery from the contractor after comparing the tax liability in pre and post GST. That means, my lord, whatever, my lord, it is not for the PVC bills, my lord, it is the normal CC bills, my lord. Whatever, my lord, irrespective of the fact, my lord, whether he has paid this the tax or not, my lord, it should be, my lord, taken into consideration, my lord. It will be summed up, my lord, and if he has paid more than, my lord, it can result in either in reimbursement to him, my lord, or recovery. All the tax, my lord, irrespective of the fact, my lord, whether he has paid the tax or not, my lord. It is
Meaning
for the
thereby-
normal CC bill, my lord.
meaning
That is for
thereby-
100 rupees.
Meaning thereby, unless there is no GST neutralization,
My lord.
he would be entitled to the 10 rupees.
Without GST neutralization. Well, yes, matlab, after coming of GST, he has to find the matlab, this GST neutralization is required.
Yes. So the GST neutralization can be found from 171.
Yes, ma'am.
It categorically says that if there is a reduction in the tax,
Matlab,
he has to give it to you. The benefit has to be given. And if he gets an input tax credit, then he has to give the benefit to the recipient. Anyway, now if he getting any, there is no reduction in the rate, we are not concerned with. Whether he is getting an input tax credit, are you not to satisfy this code? How?
How?
Yes. How? Let us not go what the petitioner said. You have to satisfy this code. How? So that is your contention.
And now I'll try, Malab.
Please,
I'll try,
try.
Malab. I can only submit that. I'll try, Malab.
Yes, please.
Now, Malab,
Let us also understand what is the law.
I'll give you lots of a small.
Because your GST department has made you high and dry.
Yes, Malab. Exactly, Malab. Malab, I'll try to Malab, explain it through a small Malab.
Did you get a blackboard?
Exactly. No, Malab. That will create difficulty for me because I'm not sure, Malab.
Tell me.
Malab, for example, Malab, a person purchases steel for manufacturing of knives, kitchen knives. They purchase it,
They purchased the steel from Tata Steel.
Malab,
Let us say.
at the price of what rupees 2,000. And Malab, they are paying tax of 12.5%.
So they have already, at the time of purchase, they have paid the 12.5%.
12.5%. Now, Malab,
We'll make it 200.
250.
Yes, 250.
250, Malab.
So the total he pays is 2,200.
Malab, that is Malab. Malab, what I have submitted, Malab, inward supply, Malab. That 250, Malab, they will get.
They will?
They will get.
From you.
No, from Malab, through ITC. 250 for inward supply, Malab. 250 they have paid, and that is the increased price. So they are entitled to 250 rupees by way of ITC. It is not barred by 75.
You're not barred by?
75.
Let us read 17. Okay, look it up. Oh, yeah. Got it. What is the input tax fee? Now, if we see section 16,
Malab.
once a person is registered, he would be entitled to take credit of the input tax charge, which means the 250,
Exactly.
on any supply of goods or services or both to him, which are used or intended to be used in the course or furtherance of his business.
Malab.
Business of constructed.
my lord.
And the said amount shall be credited to the electronic credit register ledger of such person. Meaning thereby, when does this credit happen?
That 250 rupees.
No. Here it says shall be credited. One has to claim, I suppose.
Yes, my lord.
Once he claims,
My lord.
then in that regard it will be credited.
Credit.
Notwithstanding anything contained in this, who will be entitled to the credit of the supply of Now, if we see 16.2b,
My lord. 16
2d,
D. My lord.
dd,
My lord.
it says that a person would not be entitled to the credit of input tax
My lord.
unless he has furnished the return under section 39.
My lord.
Now, section 39, if we look into it,
Section 39.
every register other than the collector of partial furnish the electronic of course output or both input take the base. So he has to furnish every month.
My lord. Yes.
Now, if he has furnished this 250 rupees as the tax which he has already, by which he is claiming, because you would not get the benefit unless he furnishes it in its return.
My lord.
So here the petitioner has to do this aspect of the matter.
My lord.
Now, once he gets an input tax credit on that aspect, then it is your submission that he would not be entitled to this tax,
250 rupees. No. Yes. Exactly.
because that he has to pass on to.
Yes.
That is his case. Now he says that look here, I have already passed on 31 lakhs to you, 31 crores to you. Now what are you asking
My
now?
lord, they have not passed on, my lord. From total tax, my lord, if your lordship see the calculation, my lord, total tax was around 79 crore or something like that, my lord. 39 was deducted from total 79. Now he is entitled to 40 to 43 or something. He is not entitled to 79 due to the fact that he got 39 lakhs as input tax credit. So it will be deducted from the total tax. Otherwise, if railway has to give him 79 crores, then he is claiming that 39 crore from us as well as from the tax
31.
department.
31.
Yes, so
So what is
it
he
has to be
asking?
what he has.
Mr. Majumdar, what is your claim of 31 crores?
No, no, my lord. That bill is the bill of GST neutralization. Because of the increase, I am entitled to reimbursement. But From there, I am deducting this 31 crore which I have already received by way of ITC. So that I am
Yes.
giving back to them.
And that bill is for the PBC.
No.
That bill is a CC bill. But in respect to this PVC claim,
Yes.
the PVC claim arises out of an increase.
Increase.
This aspect you couldn't have been brought, you can't bring it in the CC unless the PVC is allowed.
Yes.
Isn't it?
It is separate.
Here is an increase by from 100 to 120. 100 you have already got it in the running bill,
Yes. Right.
wherein there is a claim of a, because in the running bill you will get the 100. And thereby you have also deducted the ICD, input tax credit,
No.
in the running bill.
This is running bill of CC. From there, I have deducted the 31 crore which was available to me as a ITC.
Understood. So while giving the running bill,
Yes.
you have given the benefit of ITD.
No matter. ITC, I am deducting from my bill. I am taking less. I was entitled to more because of GST neutralization. But from my claim, I have reduced that 31 crore which I have availed as ITC.
Understood. So for that 100 rupees, you have deducted that.
Passing on the ITC benefit to the railways.
Then why not on this 20 rupees while making the claim if you have got the benefit for 100? I hope you are. In a running bill, you have already made your claim because the PVC claim can't be there in the running bill.
Yes.
Because they would not allow, because that is not a part of the contract in the running bill unless they approve it. Now in the running bill, you are however allowed for claiming the actual price which is there.
Yes.
That is 100 rupees. And as such, while doing so, you have given the benefit of the input tax credit, which you have taken for this 100 rupees. Wouldn't this, for this 20 rupees,
Also.
there would be an input tax credit if it is there in the 100 rupees, in the 20 rupees also.
If I am available, that also.
And I think that is what he is saying,
Yes. If
isn't it?
Yes.
Mr. Goswami? Yes. I hope you have now understood.
entire 20 rupees cannot be ITC. It's a part of.
Absolutely.
If it is there, my lord.
No, for these 20 rupees,
Yes.
which
There
has
will be again an
increased,
ITC.
just for example, it is 18 rupees is the price
Right.
for which you have got that 18 rupees.
Yes.
They are not giving you this 2 rupees.
Yes.
And that is why the litigation is.
Yes.
Then if in 100 rupees, you have already given the benefit under the input tax credit, why not this 2 rupees?
In that 2 rupees also there may what your lordship is possibly if I have understood correctly, madam, indicating is from in that 2 rupees also there will be a component of ITC.
No. In the 20 rupees will be, there will be a component of input tax credit. For which I am saying let the increase be taken as 18 rupees.
Yes.
The 2 rupees is that particular input tax credit. And if you have already taken that, then where is the question of you claiming any further? I think you think about it, because that is what it appears, if I have understood. And furthermore, one, you may have an inquiry with your client to that effect. Look into 16.4.
Yes.
16(2)(d),
Yes.
which mandates that the person needs to, a registered dealer, in order to claim input tax credit, has to do all these things.
Yes, to submit a return.
And more particularly, 16(2)(d) says that you have to file the return in terms with 39.
Yes.
Now, every month you have to do it.
Yes.
Now, whether in this particular, thereby claiming your input tax credit, it will be 39.
Yes.
Yes.
Every registered person other than an input service distributor or non-resident taxable or a person paying tax under the provisions of so and so shall, for every calendar month or part thereof, furnish a return electronically of inward and outward supply of goods or services, or both input tax credit avail, comma, tax payable, tax paid, and such other particulars in such form and manner in which it. Now, if it is to be done every month, for these 2 rupees, have you already claimed? That will be apparent from that. This case now, as I could understand, is this.
Exactly. Exactly.
Because earlier, as I was understanding, was only on 17.5. Now, in this case, where you have already said that yes, you are receiving the input tax credit for which you have given the benefit of 31 crores, meaning thereby you are getting it for rupees 100. And 20 rupees is the price variation, which includes the input tax credit of 2. When? Tomorrow.
Out of
Day
the
after?
20.
Day after?
No matter, out of that 20, I have one instruction. Out of that 20, if there is a 2 rupees of ITC, that I have to again give it back to the railway. There is no dispute.
Now, therefore, your claim now is,
Yes.
look here, this 100 rupees I can claim in my running bill.
Yes.
20 rupees, which is the PVC, would depend upon they allowing it, because that is the requirement.
Yes.
Now, whether this 20 rupees includes an input tax credit which you have already availed.
And if I avail, whether I have to again refund.
No, once you have availed, then 171 applies.
Yes, I have to give it back to them.
Either,
Give it back to him.
Yes,
yes,
yes.
either reimbursement or
And
recovery.
therefore, you would not be entitled to.
No, madam, my PPC claim is not rupees 2 now. PPC claim.
No, PVC he has already paid
No,
on the main. It is only on the GST we are.
Well, PPC contains price, difference in price, and the difference in tax. Now, so far as price is concerned, from the running bill, whatever ITC I availed, I have redirected it to them in terms of 170.
That is on 100 rupees,
Yes.
not on the PVC,
No, not on the.
not in the
PPC.
increased amount.
Yes.
Increased amount is subject to settlement,
Yes.
where they say that out of this 100 rupees, this 20 rupees, as per them, 18 rupees is the amount which the price has increased. We have paid you 18 rupees. You are now here on this 2 rupees as to whether it is an input tax credit. Have you claimed any input tax credit on this, or it is on the increase of the price, increase of the tax? If it is so, then obviously you will be entitled to.
Supposing earlier the price of steel was 100, now the price is 100 rupees. Now there's an increase so far as the price is concerned by 50 rupees. That 50 rupees they have already paid. Now for that increased price of 50, I have to pay tax, GST. And from there, if I have availed a part as ITC, that will be definitely deducted, but not entire.
No. But that aspect is not clear from your affidavits or anything that this amount has been taken out.
That we can indicate. If I avail any ITC on PPC bill also, that I'm ready to refund. That I have got no difficulty.
But otherwise you are claiming that in your petition.
No, I'm not claiming the entire amount. I'm claiming only the under the PPC clause, whatever I'm entitled. From there, 171, if it is applicable, it will apply, and I'll have to refund a part of it. If it is ITC, if I avail a part of it as ITC, then I'll have to refund that. There is no dispute.
Now, what is your claim in your petition then?
My claim is the difference in the text. Earlier, if we take the price of steel in the base one, it comes to 50. Now, if the price increases, there will be increase in the text of GST also. That difference of GST between GST and the price had I purchased at that time.
Means the
Difference.
tax, when did you purchase? Prior to the GST or after GST?
After GST, man.
After GST you have purchased.
After GST,
Once you have purchased under GST,
minus.
have you taken the input tax credit on that?
That's what I mean. Whatever input tax credit, if I have availed, that I have already deducted from my CCP. So entire the
No,
ITC
are you saying that you have deducted on the entire amount
On
without
entire
taking
amount.
into account that your PVC has not been allowed?
No, not entire amount, only CCP.
Then that is why I'm saying about the PVC.
A part of the PVC, a part of the GST, because of PVC, which I am entitled, if I have availed ITC, that has to be deducted. To that I have got no dispute. My instruction is very clear. The final bill of PVC, if by way of ITC I avail the part, then I have to refund in terms of 171. There is no.
So what do you want now? The remaining part,
Yes.
where you have not claimed the ICIC.
No matter.
Only that?
Yes.
Okay, that I can pass an order. We'll be happy also.
Because entire
Why should we go into more complications?
entire GST, from the GST difference that I am claiming today, if I have availed anything as ITC, that in terms of 171, earlier also I have deducted from the CC bill, from the PVC also. I'll take one instruction at 2 o'clock I can revert mirror. From the PVC bills also, if a part of the GST I have claimed, which I am claiming reimbursement today, if I have availed any ITC from that amount, that I have to refund to the railway, I think there is no. I'm not saying that I'm not liable to refund.
So you admit to the fact that in your CCB,
Yes.
there was no mention of the PVC,
No.
but it is on the actual amount,
Yes.
which was prior to the PVC
Yes, ma'am.
being allowed. You have given the benefit of the ITC.
ITC. And that we have already deducted from my
ITC, you have given the benefit.
Yes.
Now we are concerned with the 20 rupees which is increased.
Yes. From there, a part 2 rupees may be again ITC. If it is there, my understanding so far is I should also redirect it to the railways in terms of 171. Still, I'll take an instruction at 2 o'clock. I'll get back. Possibly that will resolve the entire. Possibly in my understanding, there could be a difficulty from our side because we are all along maintaining that 171 is a provision by which if any benefit I have derived to the ITC, that has to go back to the railways. That I'm not claiming myself.
We'll have it on Thursday.
Malab,
Don't create any problem.
tomorrow, Malab. I'm ready for tomorrow.
No. We have heard you.
Malab, Thursday.
I'm only getting this instruction only to the.
Friday, Malab, some problem. So Friday, Malab. Then Friday, tomorrow or Friday, Malab.
It will take only 1 minute just place the
Okay, we'll
Malab,
take it up to.
at 2 minutes.
Rahul, I got a bad picture. Some company more lab than to just to see the full kit, sir. Half of all to the just from the just.
Departmental proceedings
Lots
against.
of here, the petition has already been reinstated and that the suspension period has already been regularized.
Two order impugn order challenge before law state. One order is the directed to pay the recovery amount of rupees 2 lakh without any inquiry matter. And if when I am not depositing the same, they suspended me. Base my lot 32
Why this amount has been directed to be paid?
Base my lot at the time when I am the in-charge headmaster, there is a midday meal item. The sum rice and something in there, but without my lot, the SMC president, my lot, it cannot release. And thereafter, my lot SMC, when I am released from that court, my lot, they given the clearance certificate, no any, people could permit me, my lot,
Show me the impugn order.
impugn order pays my lot 32, my lot. Pays 32, my lot, annexion 9, my lot. This was issued on 9/10/2015, my lord, and which was received on 10/12/2015, my lord. Please make kindly see, my lord.
What happened to this? 832.
What's it, that recovery?
Huh?
That amount was sought to be paid by the petitioner lawsuit.
Hmm.
That is the instruction.
Now, any amount you are claiming that has to be on the basis of a departmental proceeding.
Lawsuit.
How can you do that?
And immediately I find the petitioner as my lord, pays 33, my lord.
And an inquiry was conducted by the district officials of SSN Midday Meal, MDMS, Dhemaji, and after verification of accounts, it was revealed that irregularities in midday meal and misappropriation were found as follows. Irregularities by the present headmaster, Srimati Anju Datta, is to the extent of 59,142. Irregularities by the instant petitioner lordship, assistant teacher and earlier headmaster to the extent of 2,15,061. That inquiry was conducted lordship. Therefore, the DO Dhemaji was requested by the ADC mission coordinator SSA Dhemaji by letter number so and so dated 4/12/2015 to recover the said amount from the persons concerned and deposit in the bank account of SSA Dhemaji so and so so and so. The petitioner was directed to, by this letter lawsuit, the petitioner was directed to deposit the misappropriated amount by letter number so and so dated 9/10/2015 as per the letter of ADC DMC SSA Dhemaji by letter number so and so. The reminder letter was also subsequently served on 15th. Lordship will find in page number 35. The reminder letter was also the petitioner submitted an application. The petitioner submitted an application dated
31/3/2016, praying for reconsideration of the matter. As per the petitioner did not follow the instruction of the high authority concerned and the for irregularity in the separation of midday meal, he was placed under suspension. As he did not pay the amount, as a result, he was placed under suspension. And that suspension has been subsequently, he has been reinstated, and that suspension period has been regularized. As per my
That is one.
loss.
But what about this 2,15,000?
Lordship.
He have been asked to pay.
Lordship. That he did not pay. As a result, he was placed under suspension.
Now, why have you reinstated it?
To that extent, Lordship, perhaps I have to obtain instruction. That
No,
there
because
is
one
mention
thing-
in the Lordship.
You are recovering a particular amount from him.
Lordship.
I hope the rules of 1964 apply
Lordship.
or no.
It applies.
So this will come within the ambit of Rule 7.3, minor penalty.
Lordship. Lordship.
And in view of Rule 9.1,
Lordship.
can you impose that without a department thinking?
Lordship. That cannot. That cannot be.
You have not initiated a departmental proceeding,
Perhaps. Lordship.
and the petitioner has been reinstated when? 2017.
7
So is the petitioner still working?
Instead of that suspension period has been regularized.
That is okay,
Lordship.
In absence of
irrespective of the payment being made.
Lordship.
Is it because of the
Yeah,
fact that
payments
there
have
is a
not been
stay
made.
order?
Payments have not been made. There is a stay order.
the
Interim order.
recovery part was not paid. Only when the suspension part was paid. But that is in absence of any minor
In the
pending
next
payment
petition,
or
it
any.
includes suspension order as well as the order dated so and so and so and so. What are the two orders? 23, 24, 2016.
1/9/10/2015 minor.
That
24, 2016.
recovery.
Is the recovery that has also been stated.
State order.
But can you do so?
That cannot be Lordship. But ultimately he did not pay.
So the different thing. So we set aside that order.
Lordship.
However, giving him the liberty to initiate
Lord.
action if he-
Lordship. Lordship.
but you have not paid it.
No.
So this action cannot be done without following the rules,
Lordship.
isn't it?
There was a court order, Lordship. So,
Yeah. Because of the court order, he has not paid. That's another thing.
Lordship.
But could you have imposed without a, because in view of, let's see, 7.3, read it. You have the rules of 964. Give him a copy, give him that, Mr. Bora. Well, as I am not disturbing you, I'm only disturbing the government.
The following penalties may be made for good and sufficient reason and recovery.
Yes. Tell me, how do
Rule
you
7
bring
law.
in 7.3 with this
7.3. Recovery from pay of the whole or part of any pecuniary loss caused by negligence or breach of orders to the government of Assam or to the central government or any other state government or any local or other authority to whom service of government servant had been lent.
It's the recovery.
Loss.
Now, if you see rule 9.1,
Without prejudice to the provision of the Public Servant Inquiry Act 1850, no order imposing on a government servant any of the penalties specified in Rule 7 shall be passed except for an inquiry held as far as may be in the manner hereinafter provided.
so without being there,
Lordship.
it- But however, it's a case of loss. If it has happened, you are at liberty to initiate.
Lawsuit.
And as he is still in service, you can very well do it. Mr. N. Bora, the learned counsel appearing on behalf of the petitioner. Mr. P. N. Sharma appears on behalf of the respondent number 1, 2, 3, 4.
3, 4.
Mr.
1, 2, 3, and 4.
4. Mr. S.R. Burwa appears on behalf of the respondent number 5. Mr. Mr. B. Gogoi, you appear for respondent number 6 and 7. You appear na Sarva Shiksha Objection, mission, and Sarva Shiksha additional for 6 and 7.
Number 8, school management committee.
You are appearing. Your name?
A Gohan.
A. Kuhai appears for respondent number 8. The instant writ petition has been filed by the petitioner. Being agreed, by the order dated 9/10/2015 issued by the DEO, Dhemaji, thereby directing the petitioner to pay an amount of rupees 2,15,061 into the bank account of the respondent number 6, into the bank account of SSA, Dhemaji, semicolon, by the letter dated 24/3/2016 issued by the DEO Dhemaji, thereby directing the petitioner to pay an amount of rupees 2,15,061 in the bank account of the SSA Dhemaji, semicolon. The order dated 12/4/2016, whereby the petitioner was placed under suspension, as well as for amendments directing the respondents to keep the impugned decision, to hold the departmental proceedings in abeyance. The facts involved in the instant case is that the petitioner was appointed as the assistant science teacher at the Dhemaji Town ME School. On 24/4/1992. Subsequent to the retirement of one Karna Bahadur Chetri, the headmaster of the said school, on 30/6/2012, the Director of Elementary Education Assam, by the order dated 1/8/2012, directed the District Elementary Education Officer, Dhemaji, to allow the petitioner to take over the charge of headmaster till further arrangements were effected. In pursuance thereto, the petitioner rendered his service as an in-charge headmaster of the said school. Subsequent thereto, On 29/2014, upon the appointment of one Srimati Anju Datta as the regular headmistress of the said school, the petitioner handed over the charge. The petitioner, while handing over the charge to the newly appointed headmistress of the Dhemaji town of the school, also handed over the detailed expenditure report in respect to the midday meal fund, along with the expenditure report of the midday meal rice for the period of taking over and handing over charge of the post of headmaster by the petitioner. That is from August 2012 to September 2014. It further reveals from a perusal of the writ petition that during the same period when the petitioner was holding the additional charge of headmaster, a sum of rupees 9,60,812 was received by the petitioner as fund for the midday meal scheme. Out of the said amount, a sum of rupees 8,45,524 was incurred as expenses for the scheme. Further, an amount of rupees 27,390 was incurred by the petitioner as miscellaneous public excess expenses. The balance amount which remained was rupees 87,898, which was deposited by the petitioner in the bank account of the school. Further to that, the petitioner had also deposited the fund of rupees 1,75,600 received as expenses for uniform. However, on 9/10/2015, the petitioner received a letter issued by the DEO Dhemaji directing the petitioner to pay an amount of 2,15,061 to the bank account of the SSA Dhemaji for irregularities in the midday meal scheme of the school. The petitioner on inquiry could come to learn that a said letter dated 9/10/2015 was issued on the basis of a letter of the ADC cum DMC from a SSA dated 4/12/2015. Mr. Counselor, how do you say this? Paragraph 10 of your petition.
I'm denied the allegation.
Read paragraph 10.
That it would also be noticed from the impugned letter dated 19/2015 that same has been issued on the basis of the letter dated ADC come to issue dated 4/12/2015.
How is it possible?
That is reflected in the letter.
Now, how can there be 4/12? Can a letter be issued on 9/10 on the basis of a letter which has come into existence in December? Anyway, देखो, लिखना है, what did you write? Dated 4/12/2012, 15. Sensing foul play, the petitioner issued a communication on 14/11/2015 denying the allegations leveled against him, as well as had also requested for the letter dated 4/12/2015. The petitioner followed the said representation by another letter dated 15/3/2016, again requesting the DEO to furnish the relevant materials based on which the charge has been leveled. The DEO, instead of dealing with the letter so submitted, again issued another communication dated 24/3/2016 directing the petitioner to pay the amount of rupees 2,15,061 to the bank account of the SSA Dhemaji for misappropriation in midday meal scheme of the school. The petitioner, on receipt of the said communication dated 24/3/2016, again submitted representation on 31/3/2016, denying to the charges and allegations made therein. Subsequent thereto, the DEO of Dhemaji on the basis of Dhemaji issued the communication dated 19/12, order dated 12/4/2016, thereby placing the petitioner under suspension for committing irregularities in the midday meal rice amounting to rupees 2,15,061. The petitioner, therefore, being agreed, have approached this court under Article 2 to 6 of the Constitution. It appears that on 4/5/2016, this court had issued notice of motion and on the same date, the order of suspension dated 12/4/2016, as well as the orders dated 9/10/2015 and 24/3/2016, by which the petitioner was directed to make payment of the amount of rupees 2,15,061 was stayed. It further appears from the records that the matter had come up before this court on various occasions. But even after a passage of almost 7 years, the respondents have not filed any affidavit. On 13/2/2023, when the matter came up before this court directed the Elementary Education Department to file an affidavit in opposition, wherein there should be an indication as what happened to the departmental proceedings initiated against the petitioner. Today, Mr. P. N. Sharma, the learned counsel appearing on behalf of the Elementary Education Department, submits that as far back as on 30/3/2017 itself, the order of suspension dated 12/4/2016 was cancelled thereby reinstating the petitioner on third.
Three, 2007.
Mr. P. N. Sharma, the Learned Counsel submits that immediately after passing of the order dated 4/5/2016, the petitioner was reinstated on 30/5/2016. Subsequent thereto, on 30/3/2017, the district elementary education officer had regularized the period of suspension of the petitioner from 13/4/2016 to 31/5/2016. The Learned Counsel therefore submits that in that view of the matter, the challenge to the order dated 12/4/2016 note does not remain, does not survive any further. The next question therefore arises as regards the legality of the order dated 9/10/2015 and 24/3/2016, by which the petitioner was directed to deposit the amount of rupees 2,15,061 to the bank account of the SSA Dhemaji on the alleged misappropriation in the midday meal scheme of the Dhemaji Town ME School. A perusal of the orders impugned, that is the order dated 9/10/2015 as well as 24/3/2016, shows that the said order amounts to penalty coming within the meaning of Rule 7(3) Roman 3 of the Assam Services Discipline and Appeal Rules 1964. This court made a specific query upon the Learned Counsel appearing on behalf of the Elementary Education Department as to whether there was any departmental proceedings initiated, taking into account that it is the mandate of Rule 9(1) of the Rules of 1964 that without holding a departmental proceedings in the manner stipulated in the subsequent sub-rules of Rule 9 of the Rules of 1964, it is not permissible to inflict any penalty in terms of Rule 7. The Learned Counsel for the Elementary Education Departments, with all fairness, submits that as per his instructions, there was no inquiry conducted as is required under Rule 9 of the Rules of 1964.
There was an inquiry.
In terms of rule. However, he submits that it is on account of the stay it appears that it is on account of the pendency of the writ petition, wherein there is a prayer not to proceed with the departmental proceedings. The respondents have not taken any action. Taking into account the said submission, and as it is apparent from the materials on record that there is no inquiry conducted in terms of Rule 9, prior to imposition of the cost, prior to the imposition of the penalty in terms of Rules by the imposition of the penalty of directing the petitioner to deposit an amount of 2,15,061. This court sets aside and quashes the orders dated 9/10/2015 as well as 24/3/2016. With the above, the instant petition therefore stands disposed of. Before concluding, this court, however, would like to observe that the setting aside of the orders dated 9/10/2015 as well as 24/3/2016 for the reasons above mentioned would not prejudice, would not preclude the right of the respondent authorities to initiate such action as deem fit in terms with the rules of 1964.
These items 3 to 40.
Yes, did you get anything?
Well, I could gather that my lord later, by which it was banned. But my lord, the
When
lifting
the
of
ban
ban,
was
my lord,
removed,
that letter is not with me, madam. There's still, my lord, they are inquiring about that. But my lord, according to them, only in 2006, after this, my lord, ban in 2002, for the first time, the director of health services, they, my lord, filled up certain posts, that too of backlog vacancies. Before that, my lord, to the knowledge of the director, there was no such drive initiated by any authority under him. How this was done,
no,
my lord,
this court wants to put a question to both of you.
Lord,
Have you looked into the judgment of the Supreme Court in the case of Renu 2014 SSC? It stipulates how an advertisement has to be,
Lord, sir.
more particularly in paragraph 16 and 17. Give me the citation. Give you a copy of.
In fact, my lord, Mamta Mohanty also, my lord, deals with this aspect. That, my lord, without there being a advertisement, Mamta Mohanty's case, my lord, there is a specific, my lord, finding that, my lord, without there being a advertisement.
No, not on that. What is the requirement of an advertisement?
Lord, sir.
That is very relevant. You could say the question of transparency would be there. You have to mention how many posts.
Post will have to be mentioned. It will have to be widely circulated. In some
Widely
newspapers.
circulated is okay, but post has to be mentioned. If you see the Sipsagar one,
No, it's Dibrugarh, I think.
or Dibrugarh, whatever, the main one on which it is.
Certain post. Even in the other also, Gwalpara also, my lord, the advertised posts are 70. Petitioner before this honorable court who is claiming that they have been appointed pursuant to that advertisement. They are 76. And the select list says 75. So, my lord, there is disparity in this particular entire claim made by the petitioner. 70 posts advertised. Petitioners are 76 who has approached the honorable court stating that they were appointed pursuant to that advertisement. RTI reply furnishes a list of 75, which is, my lord, beyond, my lord, that post of 70 posts that was advertised. And, my lord, it's lesser than the petitioners who claims to have been appointed pursuant to the selection. So that part they will have to clarify, my lord, regarding Gwalpara.
But what do you say about on 4/7/2005?
Lord, sir.
On that day, you have come up that there has to be an SIU approval and all this thing.
Lordship.
Wouldn't that indicate that there is no that?
No, my lord, what has been, my lord, now, my lord, informed by the director is that, my lord, after this, my lord, notification of SIU, which came up in July 2005, thereafter only selections were held. In between, my lord, to their knowledge, my lord, because the ban continued from 2002. So, my lord, there was no selection conducted by the director himself. Even if, my lord,
Now,
the
can the joint director do so without the concurrence of the director?
That's what, my lord, they are now, my lord, inquiring about this because the documents have been placed in the reply. I have furnished a copy to them. They want some time so that they can, my lord, verify this part. And interestingly, my lord, in both these two districts, that is in, my lord, Dibrugarh as well as Gwalpara, both where selections were conducted sometimes in February or January 2015. And by within 1 month,
2005 or 15?
sorry, well, 2005, and within 1 month appointments were made. And my lord, Lordship will see that is the transition period, my lord, whereby, my lord, this new pen, old pension to new pension were there, my lord. There were records, my lord, according to them. At that time, all these things have happened. Transition period from, my lord, the old pension to new pension. Now, Lordship may kindly have a look at item 13. The affidavit in reply person relating to the Dibrugarh district.
Then
Lordship may kindly have a look at, my lord, the item 13, my lord, 1931/2020.
item 13 to 15. Now, one is that is a case of regularization.
No,
That day
that
I
is
have seen.
Shivsagar district, my lord. All cases. But
Mr.
these two-
Sinha, you don't have a case there. Regularization.
I'll try to.
No, there is no trying
No, I'll just try to
out
put it.
there
Let
because
us
of the
come on.
fact that on the face of it, these people have been appointed. What do you mean? How does the director or the joint director of health service regularize without a scheme?
I appreciate that, Your Honor. But that cannot be denied that these people have been working for 40 days.
So what?
So the only, and the basis and the entire case they have relied upon is that
Let me read a passage of a Supreme Court judgment. That day I got to wait. Where is that? Yes. Supreme Court in Uttar Haryana Biti Vitran Nigam versus Suchi Devi reported in 2008 to SC 310 say the scheme granting relating to grant of family pension was made under a statute. A person would be entitled to the benefit thereof subject to the statutory effects. From a bare perusal of the provisions contained in the provision, the family pension, it would be evident that the respondent was not entitled to the grant of family pension. His service have never been regularized. It may be unfortunate that he has worked for 11 years. He expired before or could get the benefit of regularization scheme, but sentiments and sympathy alone cannot be a ground for taking a view different from what is permissible. And this is followed not on 1, 2, 3, 4, 5, 6, 7, 8. So sympathy doesn't.
no,
Well,
I'm not talking of sympathy. What's the problem Your Lordship has on that day
no,
indicated?
first and foremost, if the appointment is illegal, that is the most important. If the appointment is illegal, the question of any form cannot be taken into account.
Your Lordship, that
The regularization is illegal without there being a scheme for regularization, and the scheme for regularization needed a court even under 226 and 20 under in view of Umaditi. It is however only permissible either to the executive or the legislature.
yes,
Then how does the joint director of health service do that?
Your Lordship, facts remain what has fallen from your lordship on the last occasion when you have been placing our submission. Your lordship has said one thing. That's, let us assume for a moment that these are appointments not in accordance with the law. But what has fallen from your lordship on the last occasion that the department.
No, it keeps on falling a lot.
No,
The
therefore I'm
thing
saying-
is whether it is put pen down, that is the most important thing.
Therefore, I'm coming to that, your lordship.
Yeah.
The lordship has categorically stated, directed them that on several occasions, they have also regularized, they have sanctioned some posts, those who have been illegally appointed in some education department. Now, admittedly, these are very poor people who have worked 14 years, they have rendered their services. Now,
But what you are saying is this court should not think about what is the duty, constitutional and the interdicts which have been put by the constitution bench in Umadi.
no, I'm not going that by that. They are not denying the fact that these people have not worked. They are only saying that no SIU approval, no approval from the DHS. And the basis, that is the report, the screening committee report, based on which those people have been terminated, are not there, have not been furnished to the petitioners. And in this is service matter, it is only the procedural law to which we can claim, rest our claim, your lordship. So at best, that can be set aside and reverted back, give us an opportunity, last and the final opportunity.
For what?
After we get the report of the screening committee, we make our submissions and replies there, your lordship. That can be done. In fact, your
No,
lordship,
first and foremost, if there was a ban by the government, how did the joint director initiate the proceeding? Tell me. How could he have done that?
your lordship, as regards
That day,
the,
yesterday, I got hold of a matter. Interesting. The person initially was appointed or something like that. He came up before the court asking for area help. This court passed an order to the effect in the year long time back, 2011, that if he is legally appointed, give him the salary. Matter came up. In the meantime, he sought for regularization. This courtlet bench came up and said that no, he was appointed against a transfer vacancy. Couldn't have been. It's an illegal appointment. That happened in 2008. 2010, in the meantime, he filed a contempt for not compliance with the 2011 order. The 2006 order.
Yes, salary.
2010, the matter came up before the in the contempt proceeding. Where is the question? It's an illegal appointment. Thereafter, you keep on seeing the state authority suspending him, reinstating him, suspending him with subsistence allowance, everything. Now he comes up and says, look here, the state authorities have suspended me, have directed that I should pay a subsistence allowance. Then give me the salary for that. But the question is whether if there's a ban out there, how could he have done it? He couldn't have exercised his jurisdiction unless there is an order by the government to that effect removing the ban, which was done in the case of the OBB teachers.
your lordship, whether the ban continued till that period, that is something has to be looked into. And
So you have to satisfy this court
Yes,
that the
Your
ban
Lordship.
did not continue till then.
if your lordships, I could lay down my hands on one of the call letters in some other department, wherein that during that ban period, which they are claiming to be, an appointment was initiated, your lordship.
Education.
I could not get hold of that. I told that, let me get it and then I'll place
Hmm.
it by an affidavit. I'm not sure of that. I'll just place it by way of an affidavit, your lordship. But admittedly, it seems, your lordship, the ban was not there till then, your lordship. From a reading of that document, it transpires, your lordship. And most importantly, the treasury could not have released the salary, your lordship.
The words used by the Supreme Court in this case, Renu says that those who come to be appointed by such arbitrary procedure can hardly complain. The termination of their appointment is equally arbitrary. The words are, those who come by the back door have to go back by the same door. See paragraph 16 and 17, Mr. Gogoi.
My lord.
Renu Hazarika is.
No, not Hazarika.
That was precisely the stand taken in White Ocean Singh, and
Huh?
that was precisely the stand taken in the White Ocean Singh, the state of Manipur in that case.
Paragraph 16, 17. So which department you are saying? By appointing on this basis during the ban period?
Your Lordship, I'll produce it, but I could not get it right now, but just I have a glance through it, but I could not put it. There was a all letter issue. All letter issue. That was what I collected from one of my clients, Your Lordship, but I could not get the copy, so I asked him to get a copy. I'll place it by an affidavit if required. But admittedly, it seems from the record, from the reading of that line, that the ban didn't continue to 2005. Your
So
Lordship.
do you have the ban copy?
Yes, sir.
I thought the matter would come to an end today.
My lord, in fact, my lord,
But
they are
it seems both of you are anxious to continue the matter beyond behold. Yes. And the issue request is not to issue any kind of letter from the country for the even if case is within 2 years.
Put another side here.
So this was intimated to everybody.
Yes, sir.
What is this? Joint Director of Health Assam, Joint Director of Health L Guwahati, Joint
Well,
Director
M
of
for
Health.
malaria, L for leprosy, TB, and tuberculosis. Well, these are different melody establishment under the health department.
But not to the Joint Director of Dibrugarh.
No, joint direct lordship is at the top melody. First, joint director of health services. So here the districts will come. It will be communicated to all the districts. So it has been marked as the blank.
And what else did I ask you on the last occasion?
Specifically on this point only, madam.
On the
But my
ban?
lord, I have now, my lord, furnished
To
a copy
obtain
of this.
such order was, oh, I also shall obtain instructions and produce such orders or notification as to when the ban dated was lifted.
Yes,
There has to be a lift.
yes, sir. That
When?
part, my lord, they sometime, my lord, I will furnish it.
I think you place it on by way of an affidavit. Because if there was a ban, the question of appointment doesn't arise.
That cannot be done.
Then it is whatever has happened. Then it has
And
to
top of that, my lord, lordship will see whether this petition 1931 to 2020 relating to Dibrugarh district, the advertisement, my lord, where there was no mention about that particular post.
where, which
Page
one?
76.
19.
1931.
Yes. But
Item
no,
30.
it will be 1931.
Item 30.
Oh, got
30,
it.
one,
Yes. Where is it?
Page 76.
Yes.
Lordship, this is a not an advertisement which was published. This is just a communication. It's an internal document, my lord. Now, Lordship will see, my lord, here,
How are you saying it to be internal document?
my lord, paper publication, my lord, where it has been published, it has not been indicated.
No. This is an advertisement by which it has been said copy to the editor
Yes, Lordship will see the name of the paper.
from Spondon, Dibrugarh.
Never heard of this one.
Huh?
That to Dibrugarh. From Spondon, Dibrugarh. That I wanted to point out.
Never heard, or is it not registered under the RNI?
That also, my lord, they will, my lord, place
No,
everything, my
it
lord,
will be
with
there.
paper.
No? You can
The
just
lordship, the
find it out.
appointments were made district wise at that moment of
Hmm?
time. Appointments were made district wise, your lord.
No, we are
It is not
concerned
a
with
specific
Dibrugarh
case
district.
that
Understood very well. But then also, what is this?
And your
From
lordship,
Spondon?
assuming that the number of posts was not there, this is an irregularity, your lordship. Assuming that the numbers of posts were not mentioned for a moment, as stated by my learned friend, this is only an irregularity. I cannot be made to suffer for that. I have shown from the records, your lordship, that I was appointed. There is a select list. My name appears. I joined my services. I have been getting my regular salaries. The bills have been prepared. It was prepared under the nose of the director of health services, the finances.
No. Therefore, you take care of the SIU. Don't worry.
Yes, your lordship.
SIU has been taken care of.
Exactly, your lordship. And therefore, on that
SIU has been taken. But what about the ban?
your lordship, that's what I'm saying. If ban would have been there, the treasury could not have released the salary, your lordship.
No. Whatever may be. If
No,
there
your
was a ban, then these people couldn't have appointed
Your lordship,
or gone for.
no, that is one aspect of the point,
No,
your
that
lordship.
is the only aspect.
Exactly, I agree to that. But the most important part is that I tried my level best, but I could not lay my hands on any document. Neither this said that this ban will continue for a long time. Your lordship, it is admitted fact that if ban would have been there and I would have been appointed during that period, my case would have been like those GTC teachers or some other teachers that I would have not have received my salary. But I have been continuously receiving my salary. So
Are you going to recover from them?
But that part, my lord, nothing is there in the termination.
Tomorrow there might be a repetition that when the health department is not trying to recover from us, they have accepted the legality of our appointment. Wouldn't it be, Mr. Sinha?
the lordship, the precise case was that they wants to create vacancy and therefore we have been out. There is nothing on record. There is no documentary evidence. There is no advertisement, and this report being.
And where is the advertisement? How did you get hold of this document? At page 76?
Lordship,
This is
somewhere
not
we
on the
could
RTI.
collect it.
This is the internal communication. This they have not received on the RTI.
Your lordship, this is something. This was hand in the office notice board also. Your lordship.
You got this document from Ahom Spondon.
I don't know. Your
Obviously,
lordship.
if there is a seal of Ahom Spondon,
Might be at.
no, there has to be. Either you have to go get it from somebody.
Your lordship, this was hanged in the notice board.
No, this can't be a document of from the office file. It can't,
Yes, sir.
because of the fact that there is a seal of Ahom Spondon.
Page 77.
So this document has to come from Ahom Spondon. Now, whether they have published it,
I don't know, your lordship. This was
Then-
back in 2004, your lordship. So
no,
we are in
understood, but
2023,
how
2
can you
years
say this to be an advertisement?
No, I'm not.
Because they, one thing is very, I hope your clients did not appear on the basis of this. No. On the basis of this document, your clients didn't appear. I suppose.
They appeared perhaps on the, not perhaps, they appeared on the basis of the advertisement published in the newspaper.
And call letters too, man.
And that newspaper is not there.
No. If we
Now,
collect-
is this document authenticated by Ahom Spondon? That these documents exist?
to that extent, I have to take it. But admittedly, in the Gwalpara case,
Huh.
advertisement which I have annexed, that is from the newspaper. Here.
Hmm?
In the Gwalpara case, Your
Which one is that case?
Yes, it is my lord item 3.
Item 4, Your Lordship.
4.
Oh.
Page 81, Your Lordship.
51.
First one.
This is which matter? Gwalpara.
Yes, Your Lordship.
Is Gwalpara.
Page 81.
Gwalpara is the best case, no?
I would say the other cases are also equally good.
No, which one is your best case?
Your Lordship, as a counsel, I would say there are all cases.
No,
Is
you
equally
said
the
on the last occasion, I asked you.
No, I wanted to start it with this case. The reason is that because here all
Because,
the
you know, nowadays,
document
one thing is there, na, you can see it. I can repeat that, what we have.
Yes, yes. It is already there in the.
It is there for 30 days. Don't worry. Yeah, page 80.
yes, sir. 80 is a type copy, 81 is the advertisement. Your Lordship.
That is.
That will make the things very clear.
Candidates should not be less than 18 years when the applications are invited to the standard form. What is the date of this?
Your Lordship, 3rd January 2005.
Huh?
3rd January 2005.
How do you know that?
Your Lordship, this was written down because this was some way it was kept by someone. It was written in Assamese, Your Lordship. So on that basis, I could say. And
It was written in,
Assamese, Your Lordship. If your
but
Lordship
the
can-
advertisement is shown in English.
No, it was in the Assamese paper, Your Lordship, I suppose, because just above the advertisement, there is something
Which
written
newspaper is this?
that,
Khabor.
Your Lordship,
Is this the newspaper Khabor?
I'm not sure, Your Lordship, I cannot make a statement.
This is a document which can be, you can look it from the archives. If you are saying, Mr. Google, kindly find out this document, whether it
Entire
exists.
records matter now will be verified by the director regarding this selection matter. They are stating that my lord, these two cases, my lord, all have been advertised during the period, my lord, December 2014. And within 1 or 2 months, my lord, both cases all have been appointed. So they will verify all the records from the joint director. And my lord, I will place it before the honorable court say after 10 days or so, or immediately after that.
These cases have been pending since 2019, and this was.
You want a disposal today? I can give it.
No, I'm not saying that. Now
Then?
he's jumping on it and saying that we will verify it. Nothing.
No, they are not verifying. Are you still verifying it?
No, my lord, since my
For
lord,
the
this
last 3
particular
years, they've been
document,
verifying it.
Well,
We
why-
are to
also
take
like-
into account Mr. Google's statement that they are going to verify it, and
Right,
that too
because,
after
my lord,
termination.
my lord, these particular records or select list has
That
not
is
been
what I
furnished to the
was trying
director.
to say, Your Lordship. And that is, these facts have not been denied in their affidavit in opposition, Your Lordship. So no pleadings, no case, forget about being evasive. There is no, forget about being specific.
My
There is
lord,
no
why
evasive
they are
denial, Your
signing up from
Lordship.
this matter inquiry?
They have not
My lord,
uttered even a
within 10
single
days
word
we'll
that regard
verify.
this
Within 10
advertisement.
days.
Let
I'm sorry,
one
I'm-
person
I-
say at a
I
time.
apologize.
What's the harm, my lord? Tomorrow, if it comes out that my lord, they are bona fide, we will, my lord, admit it before the honorable court.
That means the facts prove.
If they
that
want that, if they are so confident, my lord, that this is a genuine selection, then why they are hesitating? My lord? After 10 days, we will place everything, my lord.
Then
Because, my lord, after
you want to
select-
place what?
my lord, regarding this particular address selection, that now they have furnished in the RTI reply, in the affidavit in reply. That will verify because they have annexed the select list. Pursuant to which, according to them, my lord, these appointments were made. Because that select list was never furnished to the director for approval. So they were not aware of this, my lord. We have come to know, my lord, only when this reply was furnished, and accordingly. I
No,
need to
when you
understand.
made the inquiry, did you
Not
only
an
inquire?
inquiry, my
No,
lord.
only
Just to
thing,
verify
while
and to
making
see,
the
my lord, from the
inquiry.
records.
No, Mr. Gogoi, while making the inquiry, you only made the inquiry vis-a-vis the candidate, or didn't inquire with the then joint director?
No, not inquire to that extent, my lord. Just
Or didn't you
ask
call
the
for the,
director to furnish the records relating to selection which are available in their office. At least from there also.
did
we
you call
will
for those?
No.
Did you call for the records from joint director?
No, that will be now called for because in the reply they have annexed everything.
No. So are you saying that you concluded the inquiry with the petition in respect to the petition? without calling for the records
No.
from the joint director.
No, my lord, here the joint director was present, my lord. He was supposed to come up and my lord place everything so far as this particular case is concerned. At the time of the screening committee, my lord.
Ah.
That was the direction given to him. And on top of that, my lord, all these, my lord, 81 persons who have been terminated, they were also given the opportunity so that they can present their part too. That by furnishing these documents. These petitioners, my lord, they have never, my lord, placed this particular documents, my lord, at the time.
This
when
were
the-
with you. This were not with us. That's what we have
At least the
stated.
advertisement copy, they have annexed in the writ petition.
We have annexed everything, your lordship.
That is not a RTI document, my lord. It was there in the writ petition. So where the reply part is concerned, subsequent to this, my lord, filing of the writ petition, they applied all this under RTI, my lord, from the authorities. And now they have got it before the honorable court in the form of a reply. So everything will be, my
No,
lord.
no, understood.
Yes.
But these documents, as of now, they got it from the office of the joint director.
Apparently, my lord, yes, that we cannot deny because they have placed it before. the
They have given under the RTI,
honorable.
meaning thereby that these documents were already there with the
Yes.
joint director.
With the joint director, yes.
Then did you conduct this inquiry without the joint directors of records being taken into consideration? That is, because
Yes.
one thing, Mr. Gogoi,
I understand.
unless you put it in your advertisement, nobody keeps the advertisement for so long.
My lord.
If we are to simply say that without this advertisement, you are to first inquire and have to find out, yes, in the office of the joint director, there is no advertisement.
Yes.
And ask them therefore to produce such advertisement. But without making that inquiry, did you come to the conclusion that there is no advertisement?
No, man, that part, my lord, probably whether it was furnished or not. And the screening committee report is silent about it. But my lord, I have communication from the records I can place that, my lord, all the joint.
Are you
direction-
claiming privilege on the screening committee report?
My lord,
Are you claiming privilege on the screening committee report?
even then,
If
my
you are
lord-
not, then why you are not bringing? Because they are agreed with that.
no, my lord, here one thing, my lord,
Yes.
there was a direction passed by this honorable court that, my lord, they will appear in the screening committee. And whatever is the deficiencies that is found by the screening committee, that we will indicate in the SOCOS notice, that we have indicated exactly.
Understood.
There is
But-
no such
but
direction that we
has
have
the
to furnish the
screening
entire report.
has the screening committee given a report?
Well, against every person, my lord, in the remark column, they have given the deficiencies. That has been now indicated in the SOCOS notices regarding the SIU and all that. That those are, I can place it, my lord, regarding this.
Do you have a copy of the screening committee?
Yes,
Show me.
All the
How
record
is it? Let us look into.
That was never furnished to us.
Well,
Your
not
lord-
required,
your
my
lordship,
lord. It's
let me
not
make
a
one
inquiry
submission.
under, my lord, rule
What my-
900, my lord.
Sir Sinha,
Your lordship, I'll just
I
place.
give him that judgment. That judgment I've given him. Renu.
Your lordship,
Person who enters illegally cannot claim arbitrage.
Your lordship, one thing I just want to
Yes.
prove it right now. What has fallen from your lordship right now, that your lordship has asked them a question that whether you have terminated them without considering anything. Now they are saying that we are verifying it. It indicates that they have terminated us mechanically without, and therefore in the SOCOS notice, there is no mention that no advertisement. They only say no SIU approval, no DHS approval, appointed by joint director. So that's a black and white being projected before your lordship.
No. Question therefore arises one thing.
They are trying to improve their
No.
case on the now.
Let us not assume others. First and foremost, this court has to take a decision on the question of whether there was a ban at that relief. If the ban was there, nothing survives.
Your lordship, I could get a call letter. Just now I received on WhatsApp. It was issued by the DTOCA member secretary, District TB Control Society. It was issued to one of the person for Goalpara, directing him to appear for the written test as well as the data entry. I received it just now. Last month, we need to collect it, which I said just now to your lordship. That was there, which indicates that the ban was not there at that time. But I cannot say precisely. The records are all for you. But admittedly, one fact is very clear that they have terminated us
No, you
mechanically.
are referring out there to a ban by whom?
No. What am-
Ban by which department?
Health department.
No, that document
Yes, sir.
of a health document.
Yes, sir. That is a call letter. Your lordship.
Let us see the screening
My
committee.
lord, I'm placing the exact district I'm placing. The Gwalpara district, I am technically placed.
It's the same one, which we saw it somewhere where,
Yeah, now they have obtained another RTI application.
the screening
Yeah,
committee.
Yeah,
No,
it has been furnished to them, they've annexed it in the reply.
Oh, that is the screenning committee, Mr.
Yeah.
Sinha, you are asking for. That is
In
the
reply, it
document.
is there, madam. On the last occasion, senior counsel placed it, madam. The Nair was there.
So this is the screening committee.
Yes, we have furnished to them under
Your
RTI.
lordship, this was done way back on 2019, which I have annexed if your lordship looks at page
No, no.
542 of my Narayan Rava case. That is at 542. That was done in way back on 2019 or prior to that maybe. And this termination was given effect to 26/10/2009. And this report was furnished when 1st August 2019.
Hmm?
1st August 2019
You were given on 26/10.
and 2019.
Okay, so within time. I can take it. This is under the signature of,
Madam, there are various committees, madam, boards, where madam, they conducted the madam, review. Because in the from the entire state, madam, all the districts were madam, verified. And the doubtful person, madam, employees, madam, they appeared before the committee along with their documents. So every district has got their madam, separate reports.
Your lordship, this does not mention anything as regards that they have considered or not considered the other documents which are placed. They have not considered in details what were placed before them and what could not have been placed before them. The only thing they said that no DHS approval, no SIO approval. It means the other documents have been placed before them.
one of the petitioner happens to be Tulika Hazarika. No available records found in this directive. Bilal Hazarika, no available records. But you have been getting salary from 2012. Pankaj Kolita appointed by Dibrugarh dated 17/3/2008. No DHS approval, no SIU approval of the government. Now, when did you get appointed? In 2000?
2005, your lordship, 2005.
In Golaghat?
No, 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 no.
So GR, my lord, placing now, my lord, the case is my lord,
Yeah, lordship.
Gwalpara and my lord, Dibrugarh. According to them, where there was this advertisement, there was a proper selection.
Lakhimpur?
No.
You're not into Lakhimpur?
No, Lakhimpur, there is other case.
Understood.
The other, yes, madam.
No record found in
Sipsagar,
74, no
Gwalpara,
SIU
Tinsukia,
appointed by
Borpeta.
Joint Director Lakhimpur. This is 2008. These are dated turning in 2008. No SIU approval, none. So why I'm saying, see, those appointments which have happened in 2005, just for example, in number 7 pertaining to Lakhimpur,
My lord.
this person, the one Raju Gohai, was appointed on 11/2/2005 as per service book. Here, the observations made is no SIU approval. SIU approval was required from 4/7/2005.
Yes, your lordship.
Appointed by Joint Director, no DHS approval found in the record. So in this case, there is no mention about the ban period.
Lordship, the district is Lakhimpur.
There is, expert of finance could not force seven on the state area was not. The government direction not to execute any kind of enforcement even in cases in which
Lordship, here, Malab, so far as the Lakhimpur district is concerned, Lordship may kindly have a look at the repetition, Malab. It is item number 9.
take it up at 2.
Lordship.
PVC bills. There is no dispute about this matter. For the contracts covered in para 1 above, to the contractors, and the amount shall be equal to difference of GST payable on the PVC bill and the VAT payable on that bill in the pre-GST regime. So this neutralization is in respect of PVC bill also. So if I have to pay anything for ITC,
So if there is, just for example, earlier the VAT was 10%. Now in view of the GST, it has gone to 12%. Then in that regard, you will get the 2%.
yes. One more, what?
Provided there is no input tax credit.
Yes.
Claim.
Yes. That's one more submission with the instruction that I have got from them. They say that we can make a submission before the court that from our PVC claim in respect of the tax component, we are liable to pass on the amount of ITC. So from there also, if there is an ITC, we have to pass on to them. Secondly, my lord, we would raise bills for the PVC in respect of the tax component and GST neutralization of PVC, wherein we will deduct the ITC on PVC bill, and these two bills will raise simultaneously.
So
So that
therefore your claim now remain
yes,
of the GST
right,
in respect to the PVC
right.
minus the ITC.
In short,
That's
that
it.
is in the
Mr.
language.
Goswami, that is what, Mr. Goswami,
Malab,
that is what you are also submitting,
Malab,
that they are not entitled to the ITC.
Malab.
Now, if it in a case, if they have the GST
Malab,
minus ITC,
Malab.
any amount is otherwise payable, they will be entitled.
Yes, Malab.
That you have no quarrel.
No, Malab.
And I'm told that it will be
Malab,
in terms
it
of
says, Malab, it results in, Malab, either.
Mr. Goswami,
Malab.
don't make it further
Ah.
complicated. Matters. You say that on the PVC claim, which is above for this 20 rupees,
Malab,
if the amount is 2 rupees, is taken as the GST.
Malab.
And if this 2 rupees is the GST where he has not got a ITC,
Malab,
then obviously he will be entitled to that.
Malab,
But if he has got the ITC,
Malab.
then he is not entitled to it. That is your submission.
Malab.
So under such circumstances, that is a work which they have to do it by the railways, and they will submit those things and we will take a call on that.
and it is done by way of submission of bills. This is done by way of submission of bills. So both the bills will submit simultaneously, it will be taken care.
You will
Yes,
take a call.
Malab. I'll Lordship may kindly see the next page, Malab. Para 7, Malab. Next page, Malab.
Huh?
That will clarify, Malab. That Malab, which that JPO Malab also was just now looking at, Malab.
There are 7.
Yes, Malab. 291, page 291.
Yes.
291, Malab.
Ah.
Para 7. The tax liability of the contractor before implementation of GST is to be reckoned irrespective of whether the same was actually the net effect, my lord, that is important. The net effect of GST neutralization may involve either reimbursement or contract of the to the contractor or recovery. That is the main thing. That is.
Now, there will be a recovery. This just
Yes,
for
sir.
example, the earlier amount which was there
Yes, my lord.
was more,
More.
and now GST is less.
My lord.
So on the account
Then
you will get.
recovery.
But if it is
Less
more,
than
then he will be entitled to.
reimbursement. Exactly.
So that is the long and short story out there is whether in this 2 rupees, whether he has this ITC. If he has the ITC, then he is not entitled to. If he including ITC, then also he is entitled to. He'll be entitled to. I'm only going to declare the law. Let them submit whatever documents you
Yes.
take a call.
Yes,
I'll pass the order later on. Not the order, I'll judgment reserve.
minor,
I'm hearing some other matter.
Malik.
keep your right.
Yes. Heard Mr. D. Mojumdar, the learned senior counsel, assisted by A. Batra, and Mr. G. Goswami, the learned standing counsel for the railway. Whose hearing concluded, judgment reserved.
Keep
Diplomat.
So that the registry is direct. अपनी हे तते अपन affidavit देखो ना. Yes.
Lordship may kindly have a look at the this petition.
Which one?
Make these a lordship.
Relating to Shivsagar district.
All like this.
Which petition?
Here item number 1099.
Which petition number?
WPC number 8999/2019.
It's up to petition number 9.
Regarding Lakhimpur district,
Hmm?
this petition relates to Lakhimpur district. My lord. About 33 candidates are here who have been terminated. Para 3 at page 16.
Era
Para 3,
3.
page number 16.
Yes.
Lordship will see, my lord, they have not nowhere stated that, my lord, they have not furnished the advertisement here in my lord, pursuant to which they were selected and appointed.
And
And likewise in other cases too, my lord, except these 3 or 2 cases of Gwalpara and my lord Dibrugarh, in all other cases, my lord, there is not a single statement, my lord, to the effect that, my lord, they were selected pursuant to a selection process. According to them, there were vacancies were there, they applied and they are continuing. Only that part I wanted to point out. Because, my lord, this is their petition, they will have to first establish their bona fide before the honorable court, my lord.
Therefore, let him go one by.
Here, my lord, these petitioners were appointed in various districts. They have jointly filed this petition because subsequently they were
the case
transferred.
where
from
they
the
have been
local-
regularized.
According to them, my lord, their appointments are regular appointments.
So somewhere. And I transferred in the same capacity. In Lakhimpur, where you regularized?
The lordship, in that case, in Lakhimpur cases, our specific case was that we have been appointed somewhere else. Thereafter, we have been transferred.
You appointed where?
Some in,
Shivsagar.
Dibrugarh, somewhere in Shivsagar, and that was a transfer. Thereafter, they have that was given effect.
What is your basis of appointment?
The lordship, we have stated that we have been appointed pursuant to a selection process, but I have told on earlier occasion that I could not lay down my hand on the advertisement or other things.
Where is your statement that pursuant to a selection process?
The lordship at page Page 16, para 3. That the petitioner respectively begs to that the person to varied selection process. The petitioner 1 to 70 was selected.
So what was the selection process? You say that you have been under a selection process. What is the selection process?
Selection process, your lordship, maybe by an advertisement, that's what I was.
No. You are before this court
Yes, sir.
seeking an equitable jurisdiction.
Yes, sir.
You have to say what is the selection process.
Selection process is by way of an advertisement, that's what is,
Why that has not been mentioned?
I thought this is sufficient enough, your lordship.
Was that a selection proceedings? Was there a selection committee?
That is what,
What is the parameters under which you have been selected?
your lordship, the parameters of that Article 14 has been complied with, that's what I was told, that there was a selection. process.
Article 14 you are bringing in.
There was an advertisement person to which you participated, you have been called for the interview.
Nothing has been mentioned to that effect. And just for example, let us see these 17 people who are here. These are 17 petitioners.
No, there are more
Yes.
than that. 33.
33.
Okay. So these were appointed initially, just for example, here in 1 to 17 were selected against various advertised posts.
The lordship,
You are saying 1 to 17.
right, your lordship.
What about 18?
They were transferred, your lordship,
From where?
from various places. Some,
Now, whether you were selected out there,
yes, your lordship.
where is the statement to the effect? As regards 18 to 33.
I made a statement that I was transferred, your lordship.
No. Does transfer give you a right? Is just transfer a source of recruitment?
No, I'm not saying that.
Then
Because my termination was given effect to at Lakhimpur, your lordship.
whatever may be, you want the termination should be given at Nagaon.
No, I'm not saying.
Then these were appointments made where? These are all 2008.
These appointments were
So
made-
here in these cases, the question of these people,
question of ban does not arise.
Huh?
The question of ban does not arise in,
the ban doesn't apply.
and in fact, your lordship, that was.
Now
not the-
let us see page 66 of that petition.
The lordship is talking about the Lakhimpur case.
11th of April 2018,
8, your lordship.
page 66.
Yes, 11th of April 2008.
8. Now here, it says that in pursuance to a government's approval dated 13th of February 2008. Was there any approval on 13th of February 2008?
Yes, sir, my lord. But my lord, we have stated in our affidavit that there was no advertisement, no selection, no selection.
No,
That is a
in his petition, he categorically says that pursuant to an advertisement, which is there, paragraph number 3,
That we have
See,
denied in our
was
affidavit.
selected against various advertised posts.
Lordship.
So he says that he has been selected against the various selected. But what do you say about this? In pursuant to the government's approval,
My lord.
letter dated 13th of February and the Director of Health Service dated 22 to that subject to discharge without any signing in reasons and in anticipation of receipt of satisfactory PVR is appointed as grade 4 against the newly created post under the director temporarily in the scale of strength will be governed by the new pension scheme. Highly expected that keeping in view the norms laid by the health and human, you shall restrict your family within 2 days, 2 children. Appointment shall join within 20. Now, these are copies which have been given to the Director of Health Service, the Health and Family Welfare Department.
My lord.
Now, whether there was an approval on 13th of February 2008,
That my lord, in my affidavit, my lord, we have stated that, my lord, there is no selection for to the knowledge of the director. On the contrary, my lord,
but whether there was an approval by the government on 13th of February 2008, there is a letter document number. And this document number is available here, you see, and these are all given out here.
lordship.
Then, and all these then subject to the product of so and so, the grade are hereby confirmed in the same capacity with effect from so and so against permanent force. This is by the Government of India Office of the Joint Director of Health Service. Government of Assam.
My
Yes.
lord,
Yeah. So here he does it. He's been confirmed. How
This document has not been denied by them in their affidavit in opposition. There is no pleading to that.
all these appointment letters on the basis of this 2023, 2008. Then there is another government letter, 18/2/2009.
yeah, yes, my lord.
Have you taken looked into all these things?
15 to 2009, one is 13 to 2008.
Have you looked into any of these things?
23, 2008.
Now, if there was a government approval against this, have you taken into consideration those aspects?
But in the screening committee, it appears that nothing has been. But we have stated in our affidavit, my lord.
Then if you have based your decision on the screening committee report,
Lord.
which does not take into account relevant aspects, why this court should not set aside these? It seems that Mr. Gogoi, you need to carry out this endeavor freshly. Because if you have not taken into consideration relevant aspect of the matter and have just done it on the ground that they have not produced the advertisement, when the advertisement did not say that he is to keep the advertisement copy,
No, my lord, if
neither you have also looked into the reports of the joint director, because as you submitted out here that the whatever amount it is, what it was, the selection list and all these things were not within the knowledge of the authorities concerned at that point of time when you terminated.
yes, so far as that is
Yes,
district.
so these aspects having not been taken into consideration, should this court endeavor to look into all these things and not by a committee of experts to do so?
No, no.
Because there are certain government letters. Either you have to refute that these letters does not exist. Because they were appointed persons with some government, and these are all post that period. And it is not known whether that ban which was done in 2002 will continue till 2005 or when these people were appointed.
I have a reply to that. If you allow- can you permit me? I could lay down my hands on a call letter. May I just produce it now? Because it could be back in.
How do you say, Mr. Sinha, that the same call letter also is not infected with the ban?
In the records, so far as the original record that I placed on it, there are communications with the joint directors to approve, to appear before the screening committee along with all the records.
Mr. Sinha, this is a document as regards the particular contractual service.
Yes, sir.
Contractual service under a scheme under the this tuberculosis thing. There's no relation out here when you come within the government cadre. That is given by the central government thing,
Some schemes are there,
which are there, which is completely different, which doesn't come within the ambit of the
and they are
government.
not against sanction post and all. It's a contractual.
Because if I remember, I did that matter, Mr. Gogoi, you were there, the contractual appointment, which was given only for 6 or 8 months,
Yes.
then the matter came up before a bench by which there was a direction to that effect for regularizing him for a year, without taking into consideration the contract period was only for a particular
In the
period,
review petition.
and I have reviewed it.
Yes. So these records, that the original records that I placed on it, probably that will give, record will reveal whether the direction was given to the joint directors to produce, to appear before the screening committee with all the records. If at all they have,
To whom?
to all the joint directors, to appear before the screening
No.
committee.
I understand. But if the joint director is not there, you have to come up with a finding to the effect that yes, the joint that there is nothing on records to that effect.
None.
And thereafter you have to take the next call asking the petitioner to show some other document. But it seems that you have not even taken into
That
account the
exercise is
select
there.
list in question.
That exercise is there.
Huh?
It is there. Because more than 2-3 times, they have been terminated. Initially, there was an inquiry, internal inquiry. Pursuant to that, they were terminated. They approached the honorable court because of non-furnishing of suppose notice, we have to reinstate them. Thereafter, we have considered this screening committee. On the day when they were supposed to appear, before that, they approached the honorable court. Honorable court directed that they will appear, but after the screening committee, whatever is the finding against each of the candidates, we will have to intimate them through a so-called. Only that part, what anomalies has been found against them.
Understood. But the thing is, there are many other aspects. Just for
Lots of
example, in
documents.
this case, there are various appointment orders which are based upon government orders or the director of health service orders.
Balance.
So can you say now that if those approvals are actually, whether those documents exist? And if those documents, have the screening committee looked into those aspects, which is however not clear from this chart which has been prepared by the screening committee?
That mechanically 2-3 points there. Yes, I also after going through this, I was like, first question should have been where is the advertisement? Select list, thereafter call letter and appointment. Only they can furnish that part. SIU is a part relating to the.
But Mr. Uwe, one thing which is very difficult for this court to take into account is that how can we insist on the basis of any advertisement that if you have failed to produce the advertisement, your thing is gone?
But we can.
When you have all along allowed them to function and you have paid the salary. When the SIU has given the approval and given him the salary, you have prepared the budget, everything has been done. Then why the SIU finance department, for whom you will otherwise represent, have not put any objection all this while?
But that's the scam, all our
The scam is with the SIU.
No, with the health department regarding appointment of grade 3 and grade 4.
But no
That's
action
why,
against the erring
inquiry was
officials.
conducted for all the grade 3 and grade 4 employees, not only for 1 or 2.
Understood, there are made lots,
One
but
time there was
but the
taken.
fact is, you see, if there is a ban, the appointment was illegal. There's no quarrel with that. But how do you take care of this 2018-19?
No, 8 and 9, here, our stand is this, so far as the appointments are concerned, there will have to be a selection. There will have to be a record with the authorities, Here, those records are not there. Despite that, they have come up with the appointment letter.
This is in the case
That's
of
why we have asked them.
this case is of Lakhimpur. Let us see the Lakhimpur.
We have filed a reply. Where is that, Here, why they have not applied for RTI? They are aware, my lord. They would have otherwise annexed all those advertisements, select list, everything, my lord.
Let us see the Lakhimpur business. What do you think? Lakhimpur, yes. No records found in reference to file number 2008 approval, but yes,
It is there, my lord.
yes, it is there. No record found in respect to file number 519. No SIU approval. No SIU approval. Appointment by DHS Viman. Yeah. No DHS approval found on record. Appointment by so and so Lakhimpur. No DHS approval found. No SIU approval. No appointment by so and so. No DHS approval found.
Only in respect of two committees, my lord, a detailed, my lord, remark was given. Otherwise,
No appointment and no DHS appointment by no DHS approval found. So these aspects have been taken into consideration.
my lord.
And you have put them to notice about this no DHS approval.
Yes.
This has been,
Yes.
it is reflected.
SIU understood, but why are you here also saying that a government letter of 11th of April 2002 is applicable for those appointments which has happened in 2008?
In the last portion. my lord. It is there.
When they didn't feel like removing it.
In fact, your lordship, the letter which was marked to the joint director, it categorically says the suggested by the scrutiny committee. The review list. It does not say this is the report of the screening committee based on which it has been directed or advised. This is suggested. It's a form of opinion. It indicates that there is no clear-cut finding. If your lordship comes to page 288 of my writ petition, that's the thing.
No, Mr. Sinha, all these things are different. But first and foremost, if the document on which you have been appointed, it does not exist,
It's only in the case of two of the persons, your lordship.
not two of the person.
Yes, your
The
lordship.
DHS approval which is being mentioned out there in your appointment letter does not exist.
It is in respect of petitioner number 1.
Are you saying that the DHS approval exists? You see, in against each appointment, there are two orders which have been mentioned. One is the government's letter
Yes,
and other is the DHS approval.
yes.
Apart from the fact that there has been no SIU, whatever it may be, that is another aspect of the matter. But be that as it may, the first aspect of the matter is the DHS approval which have been mentioned. Now, if that document does not exist, don't you think that the entire appointment letter is gone?
Your lordship, what I have with me in page 288 of the writ petition, which I've annexed, which was not given it to me, but I could lay down my hands on it.
Which one?
The report.
Oh, yeah, you got it.
No, I didn't got it. They have not given it to me. That's my specific stand and they have not denied it, your lordship.
Okay, now what do you want?
Therein, it is stated that in persons to the Honorable High Court order passed in such and legal advice of the Standing Council Department, you are hereby directed to issue fresh shoppers notice to pay grade for employees, citing specific deficiencies mentioned against their name, individually to remark column as suggested by the scrutiny committee during screening. Furthermore, you are also directed to give one such and such. Now, this is said they have enclosed the list of the fake grade 4 employees. They have nowhere given the finding of the scrutiny committee or the screening committee saying that why this is bad. Why
You want a similar order, I mean, similar the scrutiny committee should act similarly as the High Court by giving reasons?
That was the specific direction of this honorable court in the earlier round of litigation. To
In the
provide us
remarks
with the
column, they have
opportunity of
given it.
hearing also, your lordship. The entire case is
Yeah.
based.
Your termination order may be subject to reasons. The scrutiny committee is only going to look into those aspects only as to whether you fulfill those or not, that they have come up with findings to that effect.
Exactly, but if you provide me with the report. provide me
Report
with
for what?
The findings of the scrutiny committee.
What is the report? Is you have it now?
No, they have not given it to me, your lordship. This is post.
Understood. They have asked, the court has only asked that to point out the deficiencies. The deficiencies, the 3 or 4 deficiencies have been pointed out to you, that there is no SIU approval, no DHS approval, as well as there is no advertisement or something also, there is no selection
No,
proceeding.
that they have not stated so that there is no advertisement. In my humble submission, what I want to present to your lordship, that admittedly, your lordship has come to a finding, and sorry, I'm not finding, admittedly, your lordship has.
I have not yet
Yes.
come to a finding,
No, no,
because
immediately
the
a
finding
lordship has-
keeps on.
That there are some anomalies with regard to the department also in conducting the inquiry of lordship. They have not conducted in a manner as required under the law or as per the direction.
Tell me, what is the manner in which they should conduct?
Your lordship, they have not stated that what documents were sought from me and what I could not give it.
They have said that there is no DHS approval. You produce the DHS approval, you have it.
Your lordship, DHS approval was not required at that
They said
moment.
that there is no DHL approval which is available in their records. So without the DHS approval, which is based upon your appointment order, that itself becomes bad. That is what they are standing.
But that cannot be. That is what I have tried to.
Oh, you are
demonstrate.
saying if cannot be, then prove it.
No, I have-
That is the chance. That is why the show cause is being given to you.
Your lordship, the show cause notice was issued by.
Did you ask for the RTI, the DHS approval letter dated so and so?
Your lordship, in the cases of Gwalpara district, have made an RTI that as and when from which date the DHS.
No. Did you ask for that particular DHS approval in respect to your letters by which? You see, you have been issued the show cause.
Right.
Asking, let's see, you don't have a DHS approval.
Yes.
Did you file an RTA to that effect, which you have brought in respect to the other case, that there is, whether this DHS approval number so and so exists?
I
Did you
have-
do that?
I have done it in case of Gwalpara.
Very well. What did they come?
They have replied nothing. This office has not received
Okay,
it.
very well. Then did you file an appeal against that?
No, that was after the writ petition was filed. That's what I'm saying, your lordship.
Understood. You have gone to the RTI. Did you file a reply? If they didn't do it within 30 days, doesn't the right accrue upon you to file an appeal against that?
No, the question of appeal, filing the appeal does not arise
Why?
because they have given me a reply that this office has not received it.
No, I'm only asking you, did you ask the director of health service that whether this particular number of DHS exists? Did you ask that? No. Why? You have asked many other things. Why not that?
Your lordship,
Your entire basis of your appointment is on the basis of that approval which is being mentioned. And if that document does not exist, wouldn't your appointment be a fraudulent document?
your lordship, that is what I have asked in the Gwalpara case, that from when the requirement of DHS approval was there in this department for appointment. They said this office has not received any such instruction. Now the question is that every time the director.
Then why in your appointment letter,
Ah.
it has been mentioned that there is a DHA approval?
As regards the appointment, that is the internal issue.
There's no internal. If your document, when it is said the subject to the document mentioned so and so, the DHS approval dated so and so, this is, you are hereby appointed.
Your lordship,
So your appointment was subject to the document, and if the document does not exist, where is your appointment?
every time the director writes to the joint director, you issue show cause notice, you terminate them. Is it not sufficient to indicate that the person, the joint director is my appointing authority, therefore he is terminating me, he is issuing me the show cause notice?
But Mr. Senior, don't you think that the larger interest involved where the Article 14 and 16 has been violated without taking into account that there was no selection proceedings, nothing there. Joint director has appointed you at his sweet will.
If I may submit with all humbleness, your lordship,
Yes, please do.
that there has been some anomaly on the part of the health
Now
department.
that becomes better.
Yes, your lordship. Now, things are not so clear. The cloud is getting a bit darker. It was not so clear when they made the inquiry, your lordship. So this should go once again, your lordship. These cases should go once again for an inquiry, and they should get a fair opportunity
For what?
to submit their cases. Your
I
Lordship.
you just produce me the DH's approval, I'll direct immediately.
Your Lordship, that's what I have stated in the reply to the show cause notice.
No, you show me these things, the DH's approval. In these letters, there has been mentioned that subject to the order of the government as well as so and so, you have been appointed. Show me this document, only one of them. You have so many 34 petitioners, only one document.
Your Lordship, these are grade 4 employees. Last occasion also, Lordship has said that they're not supposed to know about the niceties of the appointment. That is what I've stated in my reply, Your Lordship. I'm not denying what is fallen from Your Lordship, but what I'm trying to, I need a fair opportunity. This
For
is
what?
to present my case, Your Lordship.
How many times do you want?
Your Lordship, this is the.
Already
occasion,
the
but-
third time has happened.
No. Third time has happened. I agree to that, Your Lordship, but the health department has not conducted in a manner as required, Your Lordship. That is very apparent from all these documents, Your Lordship. Might be some of them are fair, might be some are not. How will that be determined, Your Lordship? In
That
the-
is why you have a right to be heard.
Yes.
When? When? You have to have a legitimate expectation.
Yes, sir.
When can you have a legitimate expectation? You have to have a claim.
The claim,
Where is your claim? Your claim springs from the document DH's approval.
yes, sir.
And that is not a document before this court. How can you have a legitimate expectation applying the same?
Oh, no, that is what I have stated. I'm again saying once again, I hope I have not reiterated, Your Lordship, that this is something might be a irregularity which have not been given it to me. So provide me with that. I have stated in my reply.
Will they be happy for working for 15 or 17 years out there? Would they come under a new pension scheme,
Yes.
irrespective of termination?
Yes, but my lord, after termination.
Because after that, but you have given them, you have taken them the whatever salary or something you have taken their contribution.
Lordship.
You got 15 years of service. Should be happy with that.
The only thing I can pray for, Your Lordship, is that
Ah.
that admittedly it does not seem what I feel from reading of these documents, also something not there, that admittedly there cannot be any ban, Your Lord. Admittedly, when these appointments of Gwalpara, the Sipsagar and this Dibrugarh was made, these were made definitely after 2005, some after 2005, in the year 2008-9. And the manner in which they have conducted the inquiry, it seems that vacancy was sought to be created. That's my specific stand, Your Lordship. So, other than Gwalpara and Dibrugarh, I will pray to Your Lordship that this cases has to be revisited by this scrutiny committee as regards our claims here. That's what, in fact, in the surveillance worker cases, they have no appointment orders letter at all. I'm just presenting to Your Lordship
Very well.
in before the division bench, where my learned senior friend, respected senior Mr. Kane Chaudhary was arguing, and I was assisting in that. And the division bench has directed, okay, even they do not have a appointment order, let them go and appear and present, provide them with an opportunity to present whatever documents they have. And accordingly, those cases are allowed. And here is a case
No, it
where
was not allowed, it was dismissed. My lord. The dismissal order was appeal. He is wrong in that. I was therefore that.
I'll present the judgment, Your Lordship. I'm
Yes,
not
yes.
making a judgment at its whims and
No,
caprice.
Yes,
no.
I have it. my lord.
Don't you think that judgment will give you a good point in filing an appeal?
No, Your Lordship. These petitioners are already, I don't.
But
want to go
anyways,
for it.
no further spoiling of the judicial precious time of the court.
Lordship.
You file your affidavit,
I will file on affidavit.
bringing on record the ban until when the ban was there.
Lordship.
We'll take it up and also give something on this, what we have found as regards this
To dismiss, my lord.
additional affidavit which have been filed
Yes,
on the
sir.
basis
I
of the
will-
RTI.
Yes, sir.
And in the meantime, if you can get hold of this, I'm giving you 1 month time.
No,
The
Your
reason why I'm giving 1 month time is this. No, I'll give you more than. Fix it or- 11th of May. The reason why I'm fixing is this. In the meantime, you file your RTI asking for this approval. DHS from the director. This is a basic point. That is 1 month. We apply from tomorrow.
It might be, no, they have to come for performance.
Huh?
They have to come for performance. This is your purpose. Because there's.
Mr. Sinha,
Yes.
don't think that I am sitting out here for the first time without knowing what is the Right to Information Act. Is it required that that person has to come? Can't you apply it by yourself?
I'll do.
Mr. R. Sinha, the learned counsel appearing on behalf of the petitioner. Mr. P. Gogoi appears on behalf of the Health and Family Welfare Department. This court on, what is the order? Hey, can you record me right here? I record for this court by the order dated.
21, Your Lordship, 21, 3,000.
Oh, there are so many cases where the order has been passed.
Your Lordship, the
Oh,
order
yes.
might be in the first, second. Case. It was on 20.
This court by the order dated 21/3/2023 had directed the Mr. B. Gogoi, the learned counsel appearing on behalf of the Health and Family Welfare Department to bring on record the notification dated 11/4/2022, as well as also to obtain necessary instructions and produce such other orders or notifications by which the ban dated 11/4/2022 was lifted. Today, Mr. B. Gogoi has produced the notification dated 11/4/2022 issued by who they had 2022 issued by the Health and Family Welfare Department, whereby there was a ban on issuing appointment orders. He has also produced a follow-up notification pursuant to the notification dated 11/4/2022, whereby there was a direction to all the joint directors of health services to comply with the notification dated 11/4/2022. The learned counsel for the respondent, health department, further submits that taking into account the voluminous nature of the additional affidavit by which the various documents have been brought on record by way of an additional affidavit, you would require to have instructions in the matter. Taking into account the above, let this matter be listed again on 11th of May 2023. Taking into account the matter has been heard at length, the matter shall be.
Your Lordship will
Not
keep
like
part of it.
No partner.
No, Your Lordship.
A person can keep a partner for 1 month, and I'm making a partner to be taken up after 1 month. It doesn't look
Your
like.
Lordship will fix it before that.
On
within the
that day, my lord, it can be, my lord.
Huh?
The
Prior
hearing
to
will be
that-
completed on that day, my lord. Lordship may keep it as part of it, because I will place the entire
last
record.
week of April,
Then I'll have to fix it on the 26th of April,
Yes, yes, no issue, Your Lordship. No issue.
27th of April. So the matter will be listed on 27th of April. Huh? Taking into account that the matter has been heard at length. The matter is kept as partnered. Full stop.
There was a direction to pay the deficit court fees that has been complied with.
The learned counsel appearing on behalf of the parties are further directed to give a short synopsis of the cases so that the matter could be taken up for final disposal on the next. You just give me, because there are in various matters it is said, so that this needs to be taken. And there you point out the deficiencies out there as to, in this matter, what is the wrong out there, what they have done.
I'm deeply obliged, Your Lordship.
Item 15.
Taking great, Yes. Mr. Kegowoi, you got your instructions?
Okay, I have not received. I have communicated, but I have not received any.
Oh, they are not giving you the instructions?
Lordship.
They don't want to, oh, that matter.
Lordship, my lord dispose of with a direction to the to stop the lordship that CPF pension lordship.
Hmm?
EPF pension lordship and giving the regular pension lordship.
Oh, that matter where these people are doing this thing, huh?
Lordship.
They want to follow the Kerala High Court. Did you get hold of the Kerala High Court judgment?
Lordship, I have not. Madras
Yes.
High Court.
Oops. Yes, Mr. Dubey, you got it.
Also, I want the case matter may be disposed of by giving me government pension minus EPF pension with all areas of government. pension.
Giving you the government pension,
Yes.
then
At that time, two pensions cannot be allowed. Then EPF pension may please be closed just from getting this pension, from the date of getting this.
so your pension which you are getting is under the EFFO.
pension.
That would be closed the moment you get the government one. That is what?
Yes, with all areas, as shown in the annexure F of the
Annexure?
F of additional.
Annexure F of additional affidavit.
Yes,
Yeah. Manoranjan Roy, date of retirement 2000, capitalized value, statute of PFO.
Page 19. This is my area of my government pension.
Areas of- Map. Yeah. How much do you want?
There is yeah, that pension areas is shown there from 1/3/2017 to 31/12/2021. 26,76,485.
Okay.
That means
So this pension you have not got.
not.
Okay.
Like pension
But
itself
what,
is not got.
how much
Area is-
pension you have received? In respect to the EFFO? Are you returning it?
No, yeah,
No, something has to be done. You can't get the double benefit, isn't it, Mr. Gogoi?
Lordship,
You have to return that, then only you will get this.
unless and until it was stopped by the APFO authority, lordship, you will not get the regular pension. The regular pension
Therefore,
will be
whatever
counted.
may be, he is asking for the areas.
Lordship, regular pension should be counted from the date of lordship stopping of the EPFO pension. Lordship.
Otherwise, they will be
Lordship,
resulting
there
in
is no question of
the
area.
double if I have to give you the areas.
Lordship,
no,
there is no question
area
of area.
of my cat pension. That pension is not yet given to me.
Understood, but you have received the EFFO for pension, but you have to return that.
No, I am not asking from him. There is also EPF pension also area also that I have not asked. There is also area by the side of it. EPF pension is there is also area.
That area which is there, you are entitled to, it's okay. But this area can't be there. Kindly see page 19.
Lordship, I have seen.
There are two aspects. One is the EFFO,
Lordship.
period.
Lordship.
So if he is entitled to, he will be entitled to this
Lordship,
7,96,000.
that will he is entitled. Lordship.
But as regards this other one, he can't get till the EFO is not
No,
closed.
Lordship, it cannot be Lordship, because Lordship he is already getting the APFO Lordship. Unless and until Lordship stop by.
Yes, you want to say you want to give something more to the AII?
It is.
Office.
Regular pension lot, if he is getting rupees 10 lot, if he is entitled to, EPF he is getting 6. That is the difference.
Understood.
So,
But-
my lord,
But can he get the area for the other pension? Unless he returns, he will get, provided he returns all the EFFO pension. EPFO pension he has to return, then he can get this. Otherwise he can't.
current, my lord, there will be no difficulty because once it stopped, he is getting the regular.
Regular pension.
My lord, we direct that authorities will sort out this issue between them, lord, so far as area is concerned. Whatever he is entitled, he should get.
No. There the problem will arise, na?
But if required, he will have to refund money. That's what, my lord. I don't know, my lord, how the EPF would adjust with, my lord, the regular.
EPF part that he's been receiving. Yeah, yes.
We still have a glass.
So far EPF part concern, pension part, so whatever is he has received yet, and now to regularize the part that is the government pension. So lordship is right to say that yes, it will come only from the day it is give order passed. Now the earlier order, so refunding part, there is a procedure, then he is to, that is adjusted, and our stand is also there in the earlier also, just adjustment part was there. It has been adjusted, the part he has received from the EPF part, then only regular pension may come. There is a provision. But as you lordship has pointed out, there can only 2 pensions. That is why one person he will be entitled, and the claim that is made from the sense the last occasion, that cannot be, because he has already received the EPF part.
He can't get double.
No.
But he has to return the money.
That adjustment part, that will be as he
No,
proposed.
if he wants to get the
Regular pension.
government's area, then he has to return the EPFO.
Lordship,
Then only it will happen.
that may. Now that is also to be considered that lordship, there will be a problem that the contribution made by the employee, now there is being paid, and that from that fund only it is being paid. Now he is returning, we will be in trouble. However, we will sort it matter. As far as his claim concerned, that there is a areas part, then the lordship look into that. As lordship will.
How?
That is the adjustment part, may be adjustment. That is the, he is to
No,
adjust
there are 2 aspects. You are appearing for EPFO.
APF.
EPFO says at page 119
Yes,
that there is an area of 7,96,000.
lordship.
Will he be entitled as on now?
If it is not paid to him, then he is entitled. And if it is
No,
paid,
if it has been shown as areas.
yes, it is 7,96,000.
7 lakhs.
96,000.
He will be entitled to this amount.
And then
So the EPFO has to pay this amount then. And from the date of the instant judgment. Yes.
yes,
And from the date of the instant judgment,
the regular pension.
the regular pension will come in.
Good.
And the EPF has to be stopped.
That will be stopped.
And how do you stop it immediately?
Initially, there was a provision.
Because there is already, these are all interlinked or
Sure.
government, these are all computer
Lordship.
nowadays. Don't look into the manual thing it is. So it has to take some time. So how much time would it take from that, from a date of the judgment, this has to be intimated, or from the date, how will happen? Just for example, today I passed the order. Now, can I say it from the date of the judgment? Then it will have a problem of the,
Lordship.
then they have to fix a particular date. When?
That is, there will be 8 weeks time. By this time, they will sort out the matter.
How much
8 weeks time,
to do that?
I think.
How much time was given in Kerala?
Exactly.
Nobody got that Kerala order. Let me see. What
Madras High Court. Lordship.
Huh?
It is Madras High Court order.
Or Madras High Court. Nobody got it. Where's the Madras High Court judgment? Yes, Madras High Court. Let me see.
The Madras High Court will take the judgment to listen. 21 order. 21 order. Well, the Madras High Court doesn't speak about anything about this. At least
You got it?
order we only received, since not received the order. Here only in our matter only we find that the Put it up. It is conversation.
Tell you, both of all these lawyers, Mr. Dubey, Mr. Gogoi, who I thought both of you will can get me a copy of it. It's so easy, I got it. Why both of you couldn't get it?
Right, right.
What right? Does it look nice, both of you? You people say to be techno-savvy. There is writ petition number 12228. Date of the judgment is 5/12/2019. Filed by T. D. Rathina versus the government of Tamil Nadu.
One, one. Okay. Okay.
See, this aspect went to the Supreme Court and has been upheld. Very. Yet to be military. 2000. Military. Oh. Bago to email na. AC. But. Oh. Ako oh. No. Email say. Into my. Coming. Mr. R. Dubey, the Learned Counsel appearing on behalf of the Airport Authority of India. And
MK Majumdar.
Mr. M.K. Majumdar appearing on behalf of the respondent number 9.
Nine.
What is that?
EPA. Employees.
Appearing on behalf of the Employee Provident Fund Organization. The petitioner herein is the widow of late Manoranjan Roy, who served in the office of the Airport Authority of India for a period of 33 years, 9 months, 25 days, with his last rank of service as the Senior Superintendent, bracket E&M, bracket close, SG, in the Bojar Airport. The husband of the petitioner retired on 28/2/2017. Prior to the retirement of the husband of the petitioner, on 12/1/2017, a memorandum was issued wherein it was clearly noted that the husband of the petitioner has to submit the application for final payment of the retirement gratuity, CPF, GSLIS, and benevolent fund, etc., in the prescribed format. Pursuant to the said memorandum dated 12/1/2017, the petitioner's husband submitted the entire papers for his retirement benefits. Unfortunately, the husband of the petitioner expired on 21/4/2020. On 26/2/2020, a letter was issued by the senior manager HR of the Airport Authority of India, which was addressed to the husband of the petitioner, wherein it was written that during the service period, an amount of rupees 1,25,985 was overdrawn by her husband in the said letter. It was mentioned that after due payment of the said amount, his process of disbursing his government pension shall be processed. The petitioner deposited the said amount by way of a check bearing number 861129 dated 5/3/2020. prior to the husband's retirement. They are. No? Petition, husband of the petition deposit. Huh? The check numbers. In spite of that, the government pension was not released, for which the petitioner issued a legal notice to the regional executive director of the respondent number 1 with a prayer therein for payment of the with a prayer to sanction and allow the government pension to the petitioner's husband. The pension, the government pension. Upon issuance of the legal notice, the regional director, bracket ER, of the Airport Authority of India after although the said legal notice was duly received, but the respondent authorities did not act upon the same. However, it was only on 10/8/2020 the senior manager HR of the Airport Authority of India issued a communication to the petitioner wherein it was mentioned that in the communication wherein it was mentioned that the excess amount to be paid was rupees 2,57,370. And in that regard, only rupees 1,25,985 was paid. And the rest of the amount of rupees 1,31,385 was pending and was supposed to be returned to the Airport Authority of India. Under such, by the letter dated 10/8/2020, the petitioner was requested to refund the amount of rupees 1,31,385. The petitioner, on receipt of the said communication, replied through a letter dated 18/9/2020, that whatever was to be received back by the Airport Authority of India was required to be informed to her husband during his lifetime. It was further mentioned that whatever other amount which is required to be paid shall be returned only after receipt of the government pension to her husband is received from the office of the Airport Authority of India. However, nothing was done at the end of the respondent authorities, for which the instant writ petition was filed seeking a direction to the respondent, upon the respondent authority to look into the papers and as early as possible to disburse the government pension of her deceased husband. Full stop. It reveals from the records that on 12/3/2021, notice was issued full stop. Pursuant to the said notice, an affidavit in opposition was filed with the respondent number 1, 3, 4, and 5. Who are the officials? No. 1, 3, 4, and 5. That's good. The Airport Authority of India. In the said affidavit in opposition, it was mentioned that the husband of the petitioner during his lifetime was paid, number 1, CPF amount of rupees 13,88,101. Number 2, gratuity amount of rupees 10 lakhs. Number 3, group saving link insurance scheme GSLIS bracket close amount of rupees 44,415. Yes, paid to the petitioner on 30/11/2020. Number 4, employees benevolent fund scheme amounting to rupees 1560 per month for 5 years with effect from 1/3/2017. That's rupees 93,600. number 5, earned leave and half pay leave encashment, totaling to rupees 2,67,710 and 5,74,872. It has been mentioned that in total, the petitioners as well as her husband have received an amount of rupees 33,68,698. Further to that, it was mentioned that the petitioner's husband had already been sanctioned pension by the EPFO under the EPS-95 scheme, and the pension payment order have already been issued by the EPFO by order dated 29/11/2016. But what I could see out here, the case was filed something else and some different trajectory has happened, Mr. Mehdi. That is not your case at all. Understood, but what your case was this, that you are entitled to this, but you have not exercised your option now. You have to exercise your option.
If a lordship permits, lordship take up page 9, Roman para 3, but the petitioner husband has opted after that, when this entire process was going. Only thing, there was no mention in these facts in his writ petition part. Only prayer was that he should be granted pension. And the basic grievance was that no processing has been done. That we indicated, Lord, that if Roman 3, your lordship would see on 27/12/2017, the husband of the petition has submitted option for sanction of government pension. Thereafter, process was carrying on, Lord, and thereafter it was pointed out that there are some areas which require to be adjusted, and that's why notices were issued to them. And when they agree for this, and if your lordship would see the order dated 3/12/2021 by your lordship, the timeline was fixed to complete the process. Thereafter, we sought for certain documents from her. She provided us, and then process was done, Lord. Then this issue cropped up, Lord, whether both can be allowed, Lord. Then we indicated to your lordship that this is what the situation is. Then my learned friend, Lord, made an application and implemented EPF authorities and the central government.
But without a prayer.
The prayer is there, Lord, for government pension, if your lordship would see, but not loosely, Lord, there. We should not be issued commanding direction to look into the papers and go to further to disburse the government pension.
It has been further mentioned that the official, what do you mean by the official at page 6 of your affidavit?
Page 6, my lord.
Of your affidavit, para 6. 8 lines from the bottom. In this case, the official submitted. Who is the?
Petitioner husband.
Then why have you mentioned petitioner's husband on top in that particular paragraph itself? Kindly see from the 7th line from the top. Para 6. Okay. It has been further mentioned that a retired official, that the petitioner's husband had already been sanctioned pension by EPFO under EPS 95 scheme, and the pension payment order bracket PPO had already been issued by the EPFO by order dated 29/11/2016. The case of the respondents further is that the petitioner's husband submitted his claim for the pension under the EPS 95 scheme of the Employees Provident Fund Organization, EPFO, on 19/1/2016. And this request was scrutinized by the verifying with the records maintained in the office of the Airport Authority of India. And all the copies of the documents were forwarded to the CHQ. What is that?
Central headquarters.
Central headquarters on 10/3/2016 from the regional headquarters, Northeastern Region, Guwahati. Central corporate headquarters. The claim of the petitioner's husband was thereafter after scrutinized by the corporate headquarters at New Delhi. And after verification, the claim was forwarded to the RPFC. That is the respondent number 10, who is the nodal authority for sanction of pension under the EPS 95 scheme. And respondent number 10 had sanctioned the pension at the rate of rupees 11,048 per month. And the pension payment order had already been issued by the EPFO by order dated 29/11/2016. It was further mentioned that the husband of the petitioner was getting a monthly pension of rupees 11,048 per month with effect from 25/2/2015. How is it possible? Mr. Dubey, before retirement also one gets it.
Till date it says, no, sir.
Huh?
It it's a typographical error.
So what is your date?
It could be 17, my lord.
He retired when?
Two thousand 28 to 2017.
Huh?
28 to
28 or 25?
Paragraph 3 of the restriction of page 7 or this is their lordship 28 to 2017.
processing to आरंभ हुई. Process to exercise.
28 to 2017.
I will also see my lord, page 8, para Roman 1, my lord. Because that decision was pending by that time, my lord, whether, my lord, because there was some deficiency in service of 10 years, my lord, that decision came up later on, and thereafter only, my lord, people like petitioner husband who had deficits, my lord, the decision was made to give them a regular pension, my lord. Then he opted. By that time, the decision had not come.
What is this date? When did the sanction happen? EPPF. And Mr. Mehdi, why you are saying that you have not got any pension? If you have got the pension of 11,048,
Oh, that is, that was earlier, but the wife is here, he has gone about.
Huh?
The petitioner knows almost nothing. She is very uneducated man. Whatever,
and
yes, my lord, the petitioner, but what is to get government pension for that, I have paid this.
no. I have seen your entire petition. There is not a single word or whisper that you have received the other amounts. Why? You have specifically mentioned that during the lifetime of the petitioner, husband of the petitioner, he didn't get anything. Why?
Yes, but then,
Are these not false statements?
no, my lord, whatever was what I last, the petitioner also does not know.
Then?
Does not know. She simply told me that she is to
No,
get-
doesn't know, do you know or not?
Oh, yeah. I know so many.
You also don't know.
No, my lord, so many papers I have got till then. Therefrom I have prepared the case. A letter papers I have got when he finally additional affidavit. From that papers I have got the detailed paper. Actually, regarding EPF pension,
Mr. Medhi, have you anywhere mentioned that you have received these amounts subsequently? Does it show your bona fides?
no, myself.
Why would this court, when you are receiving that amount, why would this court exercise this jurisdiction by following the judgment of the Madras High Court in this case, when you are already receiving the EPFO? Why should this court at all exercise the jurisdiction in your favor? Tell me. You are receiving your PFO as of now?
Yes, now I am getting.
Then why have you not mentioned a single word that you are receiving the EPFO then? That you have received, your husband has received all these 32 lakh crore rupees? Why haven't you mentioned?
No, how much husband will get? I have not mentioned that. I have to-
No, I am asking you. Why have you mentioned that nothing has been received by the husband in your petition? And he died?
Because actually by mistake. Actually,
What mistake?
Actually, I prepared the petition for getting the government pension. Actually, if with that, I was definitely to that amount regarding EPF pension. That was actually not paid, but she's still getting EPF pension.
But that is not your case at all. Have you filed a reply in this matter? Saying that, okay, yes, I have received all these things, but I want the EPF. Have you mentioned that? Tomorrow, if anything out there, how does this court take into consideration that you want the EPF, not the government pension? Tell me. You say that you are a poor woman. You have a son? Your husband retired as a superintendent? He has got 32 lakhs of rupees before his death. Do you want to take this court for a ride?
Oh my lord, I have filed the petition after the death of the husband. The wife actually could not give me the sufficient papers at the time of it.
Now, have you thereafter
Thereafter,
have you taken any action on this? Have you taken into account all these aspects of the matter? Have you filed your reply to any of this saying that, yes, I have received and I want to go for the government pension, not the EPFO? Have you exercised that authority?
No, my lord.
Then, today I pass the order without even, I'm aware of the fact that what order this court is going to pass was about to pass. The order which this court is going to pass is that that amount has to be recovered from you, whatever amount you have got. And then you will be paid that amount, or that will be deducted from your pension.
From the pension, then that's all have to be deducted.
Understood. But unless and until it is done on affidavit by a person concerned, why should I trust you? I would have otherwise trusted another lawyer. But here is a case where it is absolutely, your petition out here is clearly, you have not mentioned anything. Is on the face of it, the statements are amounts to suppression of material facts. Let me read you the petition. You started, the petitioner is a poor widow of so and so. It starts with that. Then you see further. There's not a single that your husband, that the humble petitioner begs to state that her husband ultimately expired on so and so and did not avail the opportunity to touch his government pension money during his lifetime. That is your statement. Then, did you mention that your husband have gone and applied for the EPFO? No.
That was to be mentioned. Actually.
My
But the regarding
goodness, that
government
was
pension,
to
I
be
have a-
mentioned.
Yeah. That was to be mentioned.
Then, file an affidavit. Because of you, the time has gone. Heard Mr. PCR Medhi, the learned counsel appearing on behalf of the petitioner.
Can I point out one thing?
Yes,
I'll have to see page 9 of my affidavit.
what is there?
Roman,
You come up with the correction. What is the date?
my lord, Roman 3, my lord, for a moment.
For what?
But his husband during his lifetime, my lord, has applied for the government pension when it was approved, my lord. Because the decision came in 2017, my lord, that we have stated in Roman 2,
Page?
page 9. For that, your lordship would see Roman 2 also.
Roman 2, what do you say?
But what has happened?
We have rendered less than 10 years of
Yes,
service
sir.
in care and absorbed in the NHA as per the performer of to work out determined pension under the central government. Then I later intimated to obtain option forms in prescribed form, and accordingly option was bought from by circular to submit information by month in 4 copies. Pursuant thereto, the husband of submitted the option for sanction of the government pension on demand, which was forwarded on demand. Further, he submitted the Form 5 and other documents on demand on the descriptive roll of the Mr. Counsel, you do 2 things. First, you file an affidavit stating that you want to take this government pension and you are willing to return that or can be deducted from the monthly pension, which are to be given from there. You get hold of, file an affidavit to that effect. Second, you also file an application by which you ask for the refund of the amount of rupees 1,25,000, as well as not to deduct any further amount of this, applying Rafiq Masih's case.
1,25,000 is already returned, madam. 1,25,000.
They have returned you, so you have got that money.
He has
1,25,000
consented for
already
that.
returned during his
He has
lifetime.
consented for that, your lordship, the order dated 3/12, my lord. Because of that, the process was not held, my lord. But he consented that it should be
Only-
adjusted from his areas and all, my lord. That's how now it was processed further,
Understood.
my lord.
You have paid some amount.
1,25,000 I have paid back. The remaining 1,31,000 was directed me by the order of this High Court to deduct them from the amount given to me, from the money amount.
Whatever may be. File an IA and say that this amount need not be paid. It was on account of wrong fixation.
Yeah.
How did that amount come?
Not fixation, but he has earlier while serving in the National Airport Authority, but excess amount was drawn. by
How?
him. But because of calculations, but that's they have worked out now.
How was that excess drawal?
Not
How was it? How can a person draw excess unless he has taken on loan?
no, it was not a case of loan. But
Then how can there be an excess unless it is a wrong fixation? And if that is a wrong fixation, how can you take that money after the person has died?
During the lifetime of the
Mr.
person.
Mehdi, I'm trying to help you.
I'll look into that.
But Mr. PCR Mehdi, ऊपर एक लिख रही हूँ, लेकिन you just keep it out there. Upon hearing the matter at length, this court is of the opinion that if the petitioner wants to opt for the government pension, there has to be a clear and unequivocal stand being taken by way of an affidavit. To the effect that she will forego the employee's provident fund pension and will opt for the family pension under the government, central government. And further to that, she would have no objection to the recovery of the amounts already paid to the petitioner or her husband, a petitioner, towards family pension under the Employees Provident Fund Pension Scheme. If the petitioner is given the areas in respect to the pension, in respect to the government pension paid to the petitioner, in respect to the government pension, if the said amount payable by her to the in respect to the under the Employees Provident Fund Pension Scheme is recovered from the areas to which the petitioner is otherwise entitled from the government pension. When can you file it?
Within 340.
Within?
340.
Very well. The petitioner is further given the liberty to file an application for another. Let the matter be listed again on 11th of April.
Could your lordship keep it pardon?
This matter be known as partner.
Keep it.
Mr. Mehdi, take a copy of this. But both of you,
16
it
and
is very
17.
sad, huh?
But
Mr.
now-
Dubey and Mr. Gogoi.
We are
We
just
don't expect these things from both of you.
We have.
Sorry,
got-
Lord,
we
now
have-
only we
have
also.
got lost.
Huh?
We have got lost.
You got it.
Lost.
No, my
All
colleague has
along
followed
when
up.
I am being asking you, don't get it.
No, my process were faulty, Lord. My colleague,
Process was faulty.
my colleague pointed out that it was
Who pointed out?
my colleague.
Very well. You should have conferred with a colleague earlier. Yes, what is this matter about?
So this matter pertains to my lord, wrongful withholding of my salary.
Withholding of your
has
salary?
been- My lord, my salary has been withheld by the authorities without any justifiable reason. In fact,
Why?
there was no reason.
Why have you done so?
And
We have filed our affidavit, Lordship.
Hmm.
Lordship, may I take your Lordship to paragraph 5 of my
Hey,
affidavit?
মোৰ এটা পাঠত নাই জানো? পাঠত এটা নাই নেকি? সেইটো revenue matter to put. Mr. Dhar is there, our Dhar. Pathad matter, why that matter is not come up? Let's see it. Oh, where is it? It's a Pathad matter. He's to 90. Revenue? No, Pathad matter. ये तो ये नहीं किया लोग की पता look Pathad. Mr. Gupta will take up the matter later on. Let us take up the Pathad matter. Yes, Mr. Barbujari, you got your affidavit filed.
Item 22, 52 and 62.
You filed your affidavit. Why? You want to further allot this land to somebody else?
Some development has taken place, my lord. Lordship will kindly see the instructions.
What is that?
Well, pursuant to my lord's order dated 16/3/2023, that the learned advocate general has communicated my lord that order to the department. Now the department is making this communication to the health department.
Then? Which clearly shows the government is willing to settle this land with somebody else. So there is no seriousness on the aspect that you are going to have the second medical college.
No, my lord, from this communication, lordship will see, my lord, the requiring department is the health department. So now with regard to dark number,
Didn't the Supreme Court in the Constitution bench say the government has to speak in one voice?
the government has to speak in one voice.
Then what is
Yes,
this?
my lord.
You keep on that day when the Advocate General appears out here, you were supposed to take that instruction to the effect as to whether this is the only thing which is to be done. But what you have done is this, it seems that you are going to allot these lands to somebody else at the cost of the petitioner.
No, my lord, that is not,
Then?
that is not apparent from the face of the record.
Hmm.
In fact, my lord's order dated 16/3/2023,
Hmm.
it was communicated on the same day, my lord,
Hmm.
in the evening by a letter taught by the Advocate General.
Hmm.
Now he has already communicated.
Hmm.
Pursuant thereto, my lord, this.
I am not holding the fault of the government, the council.
Right.
It is the fault of the government.
No, Lordship will kindly appreciate the sequence of events. Here, my lord, here now the issue is with regard to DAG number 97. Now, DAG number 97, Lordship was dealing with the series, entire series.
No, there are many other DAGs also. 97, 96, 201 and 202.
But
In
majority,
96, there's a 4-story building.
majority of the petitioner's cases, my lord, pertains to DAG number 97. And so far as DAG number 97, one affidavit has already been filed by the Deputy Commissioner, which clearly spells with regard to DAG number 97. So far as the other DAGs are concerned, my lord, there is no clear spell out by the authorities concerned as to whether those lands are required.
But here this document, which is you are placing on 27th of March 2023,
My lord.
only say about DAG number 97.
No,
It doesn't say about other ducts.
No, other ducts is also there. But
No, no, they have only quoted the order, nothing more than that. You see, on top of it, see the second paragraph.
Yes, the matter is in respect of the affidavit in opposition filed by the Deputy Commissioner on so and so, which stated that land measure in so and so covered by Doc number 97 of so and so is recorded in the name of TB Hospital. And the aforementioned land covered by 97 has been proposed for second medical college, and the meeting of SDLSC held on so and so took a decision for allotment of the land to second medical college hospital, which includes the land allotted to TB hospital along with other land covered by other ducts. Covered by other ducts. So it is spelled out there. Now the Honorable High Court has passed an order dated 16/3/2023 of filing an affidavit in the matter by the highest authority of the Revenue Department, giving an undertaking as regards the use of the land in respect of Doc
I am not asked them to file. No. Mr. Saikia, who is the Advocate General out here, he said, read the order. Mr. D. Saikia, the learned advocate, has submitted that he requires a week's time for filing, for the purpose of filing an affidavit in the matter by the highest authority.
Absolutely correct.
This court has not directed anything.
Lordship is absolutely correct. My lord, there is no dispute with regard to that. Now, my lord, for
No, no, are you exercising the powers under 18 for the purpose of removing the petitioner so that you give the allotment and settlement to others?
Lordship will.
So that is
No,
no, that seems so. Only see the other file. Where is the other one? Where the affidavit they have filed?
31.
Even after you have taken a decision
Item number 31.
in the matter, what you call that you are going to have the second medical college out there. Then also there is a further correspondence thereafter also for the purpose of allotment.
Yes, my lord,
Why?
only my lord in solitary 2 or 3 cases.
Why? That means you are going to give somebody.
That
What
has
is this
been
solitary
recalled.
two
No,
cases?
that has been
The
recalled.
reason of the solitary 2 cases is because of WBC number 428.
No, my lord, that has been recalled. That has not attained finality. Lordship will kindly appreciate. It has not
What-
attained finality. My lord, some
I have
cases
asked
might-
you to file the affidavit. There is a reason why.
My lord.
The reason is otherwise you have a big problem with the WBC number 428.
Yes.
WBC number 428, there is the direction for considering the case.
Yes.
And this is the outcome of that on 17/3/2022. Then
There was a direction, my lord, to consider their case, but one direction.
no, not only that the direction remains, the direction has further gone behind. Kindly see the letter at page 83, NHRR. With reference to the letter and subject cited above, I have the honor to furnish herewith the report submitted by the circle officer so and so, dated so and so, in connection with the settlement of land measuring 1.76 R, covering dark number 97 of so and so in favor of Firoza Begum. It can be noted that the proposed land is not allotted or settled in the name of TB Hospital as per the land records available, and the proposal has been approved by the SLDC held on so and so by resolution in compliance to the Honorable High Court's order dated so and so 10/1/2000 in WPC number so and so. This was done by the subdivisional officer IC land settlement on 17/3/2022 after the resolution taken in these meetings that we are going to have the second TB hospital, what do you call that?
Medical college.
Medical college. Then and this doesn't stop there. There's another communication at page 71. Same that. This is being given to one Ravindra Shah. So while there is an attempt by the state government to throw these people out, do you want to give it to somebody else?
Those, my lord, those process for settlement of the land, lordship will kindly be able to, because I may not be able to, my lord. Those process for settlement of land, it started some time ago. Now, my lord.
Which means that in those lands, those process, because you see, 292 is not a one petitioner petition.
My lord.
It's a consideration of many petitioners.
Yes.
I think these people may also be there.
Yes.
So at the end of the day, you are going to give it to them. Then why should this court allow them to then not allowed. Repeat the direction which has been given out there in the 292,
Lord
and
Sir.
you have not challenged the direction. So why shouldn't we just say
No,
that these are
that
set aside?
direction- My lord, the direction was with regard to consider their.
Where is that order in 292? Yes, got it. It was the same order. Then I think then you bear the brunt, and there 18.2 has been taken into consideration. We passed the same order. See, the individual applications made by the petitioner within a period of 1 month from today, and upon application being made, the deputy commissioner shall give due consideration and pass reason order. Till such reason order is passed by the deputy commissioner, the status quo order passed earlier shall be maintained. But again, we provide that in event no representation is made within a year, the interim direction shall automatically withdrawn. Now these petitioners have given the representations you have given, then the matter ends out there. Why should this court?
So let the authority consider, they may,
We'll pass the same direction, that in spite of this direction, why you have issued that 18.2? We set aside that 18.2.
No, 18.2, my lord, with regard to this petitioner, my lord, they didn't come within the ambit of that order.
It is felt.
No, let him establish,
Then why shouldn't this court maintain a parity? Giving them the representation,
is one aspect of the matter, but why is the enforceable right, my lord?
not necessary.
No,
Why not maintain the parity? When this government, when you are,
one.
no, this court honestly thought initially
My
at your submission that you are going to have the second TB hospital or the government hospital to that effect, or the second medical college.
Yes,
But the revenue authorities are not serious on that matter. You are sending it. On one hand, you have taken a decision. That is why, although the Supreme Court categorically mentioned that the government needs to speak in one voice, every department has a different voice. Have you mentioned that you are going to have the second TB hospital or second medical college without the concurrence of the health department? It couldn't have been done earlier. Without there being a government decision to have a second medical college, you are reserving land. Can that be at all comprehended or conceived of?
no, my lord, now the records are clear that with regard to these plots of land.
No.
under
Tell me
this
one thing.
particular
Let us
task.
hear a senior government advocate on this aspect of the matter. You are the head of all the government advocates. Tell me one thing. Is it possible for any authority to reserve a land as for the second medical college without there being a decision taken by the government in that regard? Wouldn't that be a finance? The moment you think about a second medical college, you will think about the budget. You'll have to take a policy decision to that effect. Yes, we are going to spend so much of money out there. It has to be either put out there in the finance department also. All these aspects have to be taken. Now there is a decision taken by the land committee out there to the effect that we are going to have the second medical college in this area at dark number 97. If that be so, how serious are you? Why this court should not follow the same directions which have been passed out here? This court would have thought about it and deferred with this aspect of the matter, taking that all these aspects of the matter have not been taken and done something to that effect. If it was honest, an honest decision of the government, but it didn't seem so.
But my submission will be, but that is one decision of the coordinate bench. Lordship will take note of. Definitely. I have placed, my lord, other decisions which are contrary to that decision, which says, my lord, that we have to look it from the angle of the petitioners. They have approached the court. They have set the law into motion. Now, whether they have any enforceable right over the government land, first of all, they will have to.
Whether they have an enforceable right or not, that is an aspect which let the authorities decide by giving a reason order.
Otherwise, my lord, law is clear, my lord. I have already placed Radha Kanu is there, my lord. Rule 17 is there. Lordship has duly appreciated, my lord.
No, I have appreciated, but when the action of the government is not an honest, honest
No,
action,
that-
then obviously you cannot.
If my lord is weighing.
Absolutely,
my
this
lord
court
is
has to
weighing-
weigh
Yes,
when it's a case of equity.
yes.
Where does the equity lie?
Now, my
Yes, you understand the aspect. The moment I have to differ with this order, not only this, I have to also differ with the order passed by the division bench in the PIL. Then I have to apply what are the special circumstances on which. But if this court is not satisfied with the honest, with the interests of the government by which they want to give that land to somebody else by removing the petitioners who have even 4-story buildings, why should this court exercise that and take the pains to do that?
No, my lord, there are decisions on board.
And you have not challenged this order.
No, my lord, there are other decisions which are in our favor. That Guwahati University decision which I have played. My lord, placed before this honorable court. Lordship has, my lord, praised that decision. There, my lord, the land, particular land was reserved for Guwahati University. My lord, the petitioner therein, he came into occupation. He stayed there for a long period.
I have seen that.
Yes, he said that he was there for 25 years.
Yeah.
Division bench said that no, nothing to do. You leave. Because
Don't worry, that the decision can be taken care of because subsequent judgment of the PIL has come in.
No, subsequent decision of the PIL has come in, my lord, with only to the aspect that 18 notices could not have been done. Because by that time, my lord, a concession was given by the circle officer that those notices were issued, my lord, inadvertently, wrongly those notices were issued. And those notices were recalled. It is a part of the record. Here it is not that case. Here the facts are distinguishable on the face of the record to the extent that, my lord, that here the authorities have already proceeded. They have made up the mind. In some 1 or 2 instances, my lord, on account of earlier decision of this honorable court, some petitioner have got a leeway. Their matters have been considered. 1 or 2 persons have got their settlement. That, in my respectful submission, would not ipso facto give them a, my lord, right. It will amount to, my lord.
No, they have a good right out there. If you grant the settlement, taking into account their application, like in the case of those people who have been, on the last occasion, as Mr. Nath was saying, that in 2022, you have given settlement to the land, but now we are going to acquire that land. You are given the settlement at 3,25,000.
Item number 26.
You acquire the land at 15 lakhs. Good profit. Even you don't get it in the mutual fund.
Well, I will not
Then-
be submitting on that line.
No, no.
Lordship will
Isn't that the government money involved? Isn't it public money involved?
But
If you
here,
are so serious about that, why you have made those settlements out there and you are in the process of giving settlement to these
no,
people?
no. Here,
Yes, you are. It is already there. In spite of your decision to have it out there to give it to this government, then also government hospital, then also this is there. And this aspect of the matter is clear from today's instructions, which categorically says that you are not confident enough to say on affidavit that you are going to use this land only for the second medical college or even the TB hospital. Whereas the revenue authority categorically says that this land has not yet been earmarked as TB hospital land. This is what has been mentioned.
No, it doesn't say it. They are
Oh,
already.
No.
they are
Kindly
already-
see page 73.
they are-
Page, the last page, yes, page 83. It is, can be noted that the proposed land is not allotted or settled in the name of TB hospital as per the land records available. Then this is dark number 97 they mentioned, and you say that the entire dark number 97 is a TB hospital. Then
That is my lordship may view it from that angle, but my
no,
submission.
the view of this and the only view which this court was is that you have to be, there has to be an honest presentation of the facts by the state, which this court is far from finding.
Litigations might not come again and again here, time and again, my lord, people litigate.
then also they
They
get
have a
some
right to
right.
litigate, my lord, definitely. They have a right to
A
litigate.
person
but
who has a building for 4-story building, madam's building is 4-story, 3-story,
Yes,
1-story
Yes,
less.
wrongful occupation. I will say it is wrongful occupation.
So then also you have allowed, how did you allow a 3-story building in a GMC allotted area or the GMDA? How have you allowed it? The entire machinery is with you. Isn't the Guwahati, the GDD department under the government of Assam?
My lord,
Or is it different?
It happens, my lord.
Then
It happens.
how is it possible?
Even
How
my
can
lord,
there be a do you give a construction without the compliance under 25 as well as 337? No. Then how did they construct the 3-story building?
Even my lord, land belonging to the High Court were enclosed for a long time. Thereafter, my lord, recently, my lord, that has been made enforcement. This is nearby, my lord.
Yes, there was a deal. There was an honest attempt to get these people thrown for the purpose of building some infrastructure for the High Court. Yes, I'm telling you, you want to do it for yourself, for having a medical college, not forget about a medical college. Tomorrow you want to have it for the purpose of having a, what do you call, any trade center. Have it. Who has asked you not to? But can you deprive these people, thereby giving it to somebody else? Because they happen to be a blue-eyed boy.
No, that is not. the
That
case.
happens to be.
That only, my lord, the petitioners have, my lord, turned out a case, my lord, that look at some point
They
of
have been
time.
able to impress the court on that aspect.
Yes, but it is not the case of the government, my lord. till now.
Yes, as of now it is. That is why this court has asked that required the presence of the Advocate General, and he has given an undertaking to the effect that yes, we'll ask the highest revenue authority to give a affidavit that they are going to. I'm not concerned whether you have a second medical college, you have a second secretariat out there, have it, whatever you mean. Have something for the government, for the public,
Then, my
but
lord,
not allotments to the private.
No,
There
but-
shouldn't, at the cost of the petitioners tomorrow, there shouldn't be a multi-story building out there
yes,
of,
definitely, no.
of a group of some private companies out
Yes,
there.
yes, no,
There
that
shouldn't
cannot
be.
Even I am not, my lord, endorsing that action of the government. But
That is
here-
what the court
yes,
wants.
Yes, now.
Then
now,
why does this very aspect you can't give it
Yes.
on affidavit?
My lord, we will bring on affidavit. It is not lordship will kindly say, my lord, we have sought into action.
And this affidavit will give me a handle
Absolutely,
to
absolutely.
take care of WPC
Yes.
number 292.
Yes, my lord, not only my lord, bag number 97, 96, 97, 201, 202.
That Mr. Korpujari, we brought it up last week when the matter was taken up.
My lord,
But to give me a handle, I need that affidavit. Otherwise, that judgment of
Yes.
Justice Bhusar Burua has to be followed,
yes, my lord, in that view.
which you are not,
Yes, my lord.
which you are not willing. You want to just throw them out.
Lordship will kindly hear, my lord. I have the instructions of the learned advocate general on the strength of this letter, my lord. I am seeking some further time. I'm seeking
Tell
some
me
further-
that.
I'm seeking some
Tell me
further time.
that. Nothing
Yes.
else to the
Yes,
fact that
yes.
we are still contemplating.
No,
We
my
may
lord,
or may
no,
not.
no,
But
Lordship has given a, my lord, handle to the state government. What more we can have, my lord? Definitely, my
but
lord.
the
we will-
state government doesn't want to
My
commit.
lord, the state government has swung into action, my lord, from this letter, my lord. Kindly see, my lord. Revenue department is not
Sprung
the-
into action after 11 days.
But it happens, my lord, the government, my lord.
Even after the Advocate General said,
My lord, advocate
is
general,
that
we
the
have-
state of
we have-
affairs?
We have sorted, my lord.
The
on
High Court
same day.
advocates are in the, even the advocate, the first among equals, among the all advocates, his status has become this, with due respect,
Lordship will kindly grant me, my lord, 3 weeks time, my lord, in the
3
meantime.
weeks,
3 weeks time.
no? What 3 weeks? Get your affidavit by 10, otherwise we give him a better something, he's also on a predicament. Every time he has to answer his client work. On the last occasion, Mr. Dhar was ready to give allow to vacate after 6 months. He was ready. But look at your conduct. He says, yes, it is a medical college, good. You can go out there. Government nowadays thinks about giving free service to people. Yeah, very well. But not at the cost of giving it to the third
Kindly
party.
allow me, my lord, some further time. Because we will bring an affidavit on record. There is no better handle we can, my lord, perceive at this moment than my lord's order.
Yeah.
We are so grateful to my lord.
Handle also doesn't help. You need a
Handle, my lord.
fulcrum.
Yes, my lord. Some time is required, my lord. But people will kindly be, my lord. Kindly appreciate our position.
I'm not taking note of all this. Heard Mr. Art heard the learned counsel appearing on behalf of the petitioner. Mr. R. Officer appears on behalf of the Revenue Department and Mr. Dinath appears on behalf of the on behalf of the other state respondent. The R. Officer submits that in pursuance to the order dated 16/2023, the respondent state are taking a decision in the matter as regards the use of the land in respect to Act number 96/97/01. Therefore, it submits that we may be given some liberty to file the affidavit by 10th of April. This is the matter on 11th of April.
I'm so grateful, my lord. I'm so grateful.
Yes, yes. Mr. Nath, kindly come here. Yes, you were saying?
For DC and two other officers, DC and circle officer, I'm appearing.
I've said, Mr. Dinath appeared for all the other state respondents.
16 and 7.
My lord, the issue pertains to my lord, withholding of my salary, my lord.
We'll have it after you. How much? Since when you? Yes, Mr. Sharma, what affidavit you have filed?
File our affidavit, Lordship.
He is not entitled to.
Lordship, he has not received his salary for his own fault, Lordship.
What?
Lordship, may I kindly take up my
Is
affidavit.
it his fault or is the lawyer's fault?
The affidavit filed by the respondent number 2.
Whose fault?
Elementary Education Department, Lordship.
He is asking for a salary from April 2020 to December 2020.
Lordship.
Why? Why this amount has not been paid to you?
My lord, I represented to the authorities, my lord, asking why it has not been paid.
Yes.
My lord, they have replied to me by communication dated 17/3/2021.
Where is it?
Page 22.
Page
22
of your
writ petition. Annexure G.
2965.
My lord.
Page 22.
Page 22.
Yes, why it has been mentioned?
In the reply, my lord, they have put certain allegations against me that I have not handed over the charge, and my lord, other allegations were put against me. But those reasons are supplied, my lord, after
the period of your financial transaction over Iman, but in collusion with the Iman. For these reasons and for not handing over the charge to the headmaster, your salary has been blocked. What charge? Oh, midday meal.
No, my lord.
Lordship, may I submit, Lordship?
Yes.
Another headmaster
Petitioner was allowed to hold the charge of in-charge headmaster until a regular headmaster is posted. Now, once the regular headmaster 1 Tafiqul has been posted, the petitioner did not hand over the charge. My affidavit, Lordship, may kindly peruse. Paragraph 4.
He did not hand over the
He
charge.
did not hand over the charge. Rather, he locked the room and everything, Lordship.
Then?
And then he did not follow the instruction of the authority.
Then
And in regard to his salary also, it is clearly mentioned in my paragraph 6 of my affidavit, Lordship. He did not, he was asked to submit the necessary documents. That he did not. Lordship, may I read paragraph 6, Lordship?
No, understood. Then what happened?
Then he did not furnish the necessary documents. And there was a report from the block elementary education officer. There are number of allegations against him. That is annexed by annexure A1. And subsequently, on recommendation, he was placed under suspension.
Then
When suspension order is there, that
he's
is
still suspended.
he has been suspended.
You're getting the
subsequently.
subsistence allowance.
But he is asking for
That
the salary
suspension
prior
was-
to that period.
No, understood. But are you still under suspension?
50% I got, my lord. Thereafter, the suspension was not renewed. I am getting 75%.
You're getting 75%.
75%.
Now, have you initiated departmental
That-
proceeding?
To that,
Nothing
because
has
this affidavit has been filed in September 2022, Lordship. Subsequent development, that instruction I have to obtain.
Very well. Now, have you recovered from him this 2,30,000?
That also.
Secondly, how have you not given him the salary initially for that period?
That period, because of he did not furnish the necessary documents that are required, Lordship. It has been clearly mentioned in my affidavit in paragraph 6.
What are the documents?
Documents not specifically mentioned, but the
Specifically not mentioned.
no, Lordship, because the lock and key and everything is with him. He has put his own lock in the headmaster's room.
Now who is there? Headmaster is there.
Headmaster is there. Safiqul Haq Chaudhary is there.
Okay, now he's there. Why are you not paying him his salary?
Because he has manufactured his own registers and everything.
I know, whatever may be. For that, you take up his action for departmental proceedings. But can you withhold his salary for that?
That is there, Lord.
For that period when he worked?
Lord.
Can you do that? And this is for the period from April to December 2020. We are in 2023.
Lord,
Then how can you do that?
But there are number of allegations again.
No, allegations
him.
are subject matter of disciplinary proceeding. So cause is issued, I have replied.
That is agreed, Lordship. Let me have an instruction as
For
regards
what?
Why am I
the subsequent
challenging
development,
the
Lordship. What has happened to that suspension order? Lordship may fix the matter next week.
They have come to the
me
conclusion
have-
of my guilt, my lord. When they
Let me have my
reply, why
instruction.
without any reason, my lord, that salary.
Let me have it.
Education.
We can have it on 2020.
Lordship. Lordship. By the time I will have the
You get your instruction.
Lordship.
Not next week. Next week not possible. Next week too only we are having 1 day, 2 days, 3 days, 2-3 days, no work.
I will have
10, 11, 12 is too hectic. We'll have it on 20th. We'll get a matter disposed of. I would have passed the order today, but 4:30 doesn't look nice to pass an order against the elementary education office. Okay. I had Mr. I. Gupta, the learned counsel, appearing on behalf of the petitioner, and Mr. P.N. Sharma, the learned counsel, appearing on behalf of the elementary education. Mr. S.R. Bolu appears on behalf of the government. The case of the petitioner herein is that the petitioner have not been paid his salary from the month of April 2020 to December 2020. The learned counsel for the elementary education department has submitted that there are various allegations against the petitioner for which the salary has not been paid. This court had made a specific query upon Mr. P. N. Sharma, the learned standing counsel for the elementary education department, as to whether there has been any departmental proceedings or there has been any inquiry report on the basis of which the petitioner's salary has been withheld for the period from April 2020 to December 2020. submits that he would like to take the instruction taking into account that the affidavit was filed in the month of September 2022. Isn't it?
Lordship, September 22.
Taking into account the
16th
same, let the
September
matter be listed on 24/2023, on which date an attempt shall be made to dispose of both the petitions.
Lordship.
Yes, anything? Yes, Mr. Barbujari.
Number 18 matter.
For what?
Is the matter for passing order. Mr. Gogoi was asked to post the judgment of Jarjit Singh. That case of.
Oh, that one, office. Where is Mr. B. Gogoi? You are appearing today.
He's on late in some other court, my lord.
Okay, you want to submit?
He has prepared the brief, my lord. Otherwise, I will.
Earlier you were preparing. Earlier order, last order, before order is yours.
I can assist. Yes.
And
Let it be on some other day, my lord. Today, party all over.
We'll have it after vacation. No time. We'll have it on 27th. 27th. Is the
I'm
matter
also,
again? It's the matter of 27th. Anything else?
No, there is one matter, item number 53. It's a pension matter.
For what?
Pension matter, one is item number 53.
Mr. Council, all matters are pension matters. Tell me.
Hello, next Friday.
No, not what. Next Friday is 7th. 7th is Good Friday. Not possible. We can have it only after vacation. No, we are only 3 days are there. 3 days, you must be knowing out there that these 3 days, out of which 5 and 6, the work will be very less.
I wouldn't have followed the.
That's it. In this case, actually,
Only thing is the situation is very grave.
Huh?
Only thing is, the situation is very sensitive to the petition. Old matter.
Yeah.
Lordship, we have received instruction. We have given provisional pension to him, Lordship. Criminal proceeding is there. Therefore, department is not a position.
Or you
to
can't
regulate.
get more than that. Huh?
I can download your lot.
No, you have got, there's a criminal proceedings.
Into the provisions matter, 20, 21 and 22. Even if there's a proceeding matter, the time has gone matter. Within 4 years, that time is gone long that way.
What 4 years?
And within 4 years, that criminal proceeding that has to be considered. He has retired matter. Now the incident is.
No, if the criminal proceedings are pending.
In that case also, I'm telling the facts of the matter. 2002 is the date of occurrence. 2004 I have retired. And the charge sheet was filed in 2010. 11. So, as per the provisions, my lord, explanation, the institution has to be as on the date of filing charge sheet. And it has to be within 4 years, my lord.
4 years from where?
From the date of occurrence.
No,
Date of occurrence.
that is a departmental proceedings.
No, even criminal procedure.
No, for criminal it is cause of action.
No.
See, yes,
21 lordship kindly see. Has been
I've seen it. You see, you are saying about the date of occurrence would be from 21B2.
21D.
B2 is for.
I'm reading C, madam.
Huh?
I'm reading C.
3, yes.
Most are judicial proceedings, which includes both civil and criminal matter. If not instituted while the officer was in service, whether before his retirement or during his employment, shall be instituted. Note to be instituted in respect of a cause of action which arose or an event which took place more than 4 years before such institution. Now, the institution has been defined in explanation. It says that, my lord, in the case of a criminal proceeding, on the date on which the complaint or report of police officer on which the magistrate takes cognizance is made. So when the report was made, that is the institution. If the date of occurrence and date of institution is more than 4 years, my lord, they cannot take any action or cannot deny me in any manner.
What do you say about 22(1)?
22?
1.
22(1), my lord.
22A, my lord, A or
22-1.
22-1, yes, my lord. Yes, well, 22-1 exactly, my lord.
Yes.
22-1 says that, my lord, this deals about the pending departmental of criminal proceeding. His first line says, my lord, where any departmental or judicial proceeding is instituted under Rule 21.
Yes. No.
Then
Departmental proceedings has to be under 21.
both, my lord.
No, there cannot be a judicial proceedings under 21. How can there be?
No,
Because the judicial proceeding has to be on the basis of a criminal offense.
no, 21 has explained both.
Therefore, the use of the word depart in terms with 21, you see this judicial proceeding in terms with 21.
Well, 21, if you read the entire 21, my lord,
Yes.
it has explained both criminal proceeding, civil proceeding, as well as departmental proceeding. In our case, there is no departmental proceeding, so that question is not arising.
No.
In our case, only a criminal case was pending after I retired. Now, if you are going by the provisions that I have read before, 21C and explanation B, that means that, my lord, the institution of the criminal proceeding, the institution of the criminal proceeding, but you can see, my lord, 21C, my lord.
Yes.
I read it before. That gives the limitation of 4 years of before institution.
Where any departmental or judicial proceedings is instituted under Rule 21, or where a departmental proceeding is continued under Clause A of the proviso thereto against an officer who have retired on attaining the age of compulsory retirement or otherwise, he shall be paid during this period of commencing from the date of his retirement to the date on which, upon conclusion of such proceeding, final orders are passed of provisional pension, not exceeding the maximum pension which would have been payable to him, or if he would be under suspension on the date of refund, but no gratuity as payment shall be. Now, if we see here, you are saying that no such judicial proceedings, if not instituted, will be when the officer was in service. You retired when?
I have retired in 2004. 2004.
When was it done? Initiated?
FIR was filed in 2005, but it relates to an incident of 2002.
During the service period.
During the service.
Yes. Then.
So it says that, my lord, it has to be instituted. The word instituted is very technical, my lord, that has been explained. It has to be instituted within 4 years of the cause of action. The incident.
FI was filed in 2003.
No, 2005, but it relates to an incident of 2002.
2002. Then.
So that is the, my lord, in terms of an event.
If not instituted while the officer was in service, while whether before his retirement or during his employment,
no such judicial
shall be instituted in respect of a cause of action
which arose
or
an event
which took place more than
4 years before
such institution. So you say
now
and in here in the judicial proceeding, in the case of a criminal proceeding,
my lord,
on the date on which the complaint or report of the police officer on which the magistrate take cognizance is made. When was the cognizance taken? Charge sheet submitted?
Charge sheet submitted in 2011. I have certified copy, my lord.
Charge sheet done on 2011.
11.
And as such, your case is that it will go back.
Even if FIR date is taken, my lord, that is also more than 4 years. Otherwise, in a pending proceeding, I am only entitled to provisional pension. There is no doubt to the provision. 22 says that. But 22 says that it has to be instituted under 21. 21 says that, my lord, in case of criminal proceeding, my lord, the gap between cause of the event of filing the criminal case.
We'll look into that matter. Okay. When? Well, I think this will need a further analysis. Now, what is happening out here now? Unutilized leave salary 300, you have got it. In view of the pendency of so-and-so is pending. In view of the one.
They have said provisional pension, they have paid, madam. Is it latest, madam, something?
Your retirement is 31/1/2004.
My lord.
And according to pension papers, have been prepared in 2005.
Up till 2007, my lord, they paid me provisional pension, and from 2007 onward, they are paying me 8,000 something as a fix from that time to till date pension amount. So why, how they have not exchanged? No increase in the amount, my lord. And
Yes, madam, this aspect is not coming out from an instruction. Why you have paid only 8,400?
That's it. Provisional pension 2,851 plus other allowances. That's it. For my instruction, para number.
No, that was of 2011. This was done in 2011. Pension case by the AG Assam so and so dated 13/7, and accordingly the office of the DO is paying this amount. Very well. Now, madam, tell me one thing. After the 7 pay commission has kicked in, wouldn't there be an increase?
I have to take instruction on that.
Because I think because this is, how are you paying on the basis of 2011 thing? You have to, I think everybody gets it. You will also be entitled to the areas also.
yes, sir. So my instruction is that 8,000 cannot be my provisional pension, not higher than that.
So no, you were given on 3,851 plus other allowances, by which
I don't have, I could have taken instruction.
it's okay. He will give you I'll give you a copy of the. So this is the thing. 3,851 plus other allowances, which comes to 8,400. But this was done in 2011. There has been no increase thereafter, which means obviously there will be, you will be also entitled to areas. Heard Mr. B. Chakraborty, the learned counsel appearing on behalf of the petitioner. Ms. G. Bora appears on behalf of the agriculture department. The matter, taking into account the submission made by Mr. P. Chakraborty, this court with the opinion that the matter would require a detailed hearing as regards the applicability of Rule 22(1) of the Assam Service Pension Rules. Assam Services Pension Rules 1969. Insofar as the case of the petitioner is concerned, in as much as per the petitioner, Rule 22(1) would not apply to his case, in as much as the judicial proceedings so initiated cannot be a judicial proceeding in terms with Rule 21. He further submitted that as on now also the petitioner is only receiving 8,400,
8,840, my lord.
840 as the provisional pension. Ms. Zipora, the learned counsel appearing on behalf of the agriculture department, has submitted a set of instructions wherein it appears that it was on 13/7/2011 that a provisional pension was fixed at rupees 3,851 plus other allowances. On a specific query being made to the learned counsel as to whether the impact, whether the 7 pay commission, whether the benefits of the 7 pay commission have been granted to the petitioner, taking into account that there has been 7 pay commission has been granted in respect to the petitioner. She, however, submits that she would like to take instructions on that. Taking into account the same, let the matter be listed on 27th of April 2023, on which date the learned counsel for the agricultural department shall also apprise this court. It shall obtain instruction in that regard. The instructions are, sir, so placed is kept on record and marked with the letter X. An attempt shall be made to dispose of the petition on the next. Liberty is given to the petitioner to mention the matter for upgrading. You upgrade it. As I've already heard it. But it would not be proper to dispose of in this manner.
কপি এটা এই কপিটো দিব কৈছে
অকল এটাই কপি আছে নেকি?
হা
অকল
মই
এটাই
ফটো লৈ
কপি
লওঁ।
আছে, আপুনি ফটো কৰি লওক।
নাই নাই
আৰু গুচি গৈছে হা। মানে এটা জেৰক্স কৰি দিব পাৰিব নেকি? হা অকে সৰি মানে